Yes. Yes. The age is I will say.
Count.
Election.
Private party.
Bench. Bench के स्पीच जोड़ा.
Bench.
खाली जोड़ा लगा दीजिए. Item number 5. Okay, just note 25th. Okay, just make a note. Part 2. No, just make a note. Just make a note to call on 25th.
I would see something. One more thing.
It's okay, but in this, in item 6 also you are there. Okay.
May I please, as a lordship? My lord, I beg to mention for listing of a.
Mention, give it to the court
No,
master.
my lord, it is in connection with the election petition number 1, my lord. We have prayed for deletion of a one respondent, he has died, my lord. Therefore, that an IA has been filed for
Give it to
Thursday.
the court master. Take it up.
Obliged.
Give it to the court master. Therefore, listing, give it to the court master. She'll have to make some adjustments, but she will take it up. Court master. Today it will not come. I told you to make corrections. Okay. 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 Listing, please hear me. I am telling you time and again to give it to the court master. You don't listen it to a simple statement. Thrice I have repeated. It doesn't look nice in the morning hours to repeat same thing again and again and again.
Lordship, I kindly beg to mention, list the matter for withdrawal on tomorrow.
It is refused.
Daily list, item number 9 for withdrawal.
Upon instructions, Mr. H. Gupta, counsel for the petitioner, seeks to withdraw this writ petition. Prayer is allowed. Matter stand dismissed on withdrawal.
My lord, liberty may be given. My lord.
Why liberty?
My lord, certain documents, my lord, we have filed the petition in the vacation bench. My lord, it was filed in hurried manner. My lord, one document, my lord, the representation. My lord, we are refiling the matter today, my lord.
Okay, with liberty to approach again.
My lord. Obliged.
Yes, Mr. Mishra, top of the list.
It is, my lord. For the learned senior council begins, I have a fervent prayer, my lord. Mr. P.N. Goswami, he has gone to Kolkata for a checkup of his son.
No, but I'll have to start hearing it. There's a
It
mandate,
is, my
not
lord.
from there, but
The learned senior may begin. I'll keep notes. I'll place my case after that he can. I only seek leave, my lord. He may place his arguments on a later date, my lord.
day after tomorrow.
Could it be, my
The
lord,
thing is,
next
day
week?
after tomorrow, I have a matter, a Shillong matter, which I'll be doing virtually, but I will try and finish it today, so day after they can.
So for reply, your assisting counsel will be, can be here.
Yeah, he'll be there. We are. By this petition, we have challenged the provisional assessment dated 1st of March 2014, which was finalized by an order dated 30th of April 2014. So both these are under challenge before your lordship.
The
No, they have-
allegations are tampering.
My lord. Now, the assessment is made under section 135, read with the appropriate clauses of the supply code. They have, my lord, taken a point, not so far as to challenge the maintainability, but they have made a hint, saying that there is an alternative remedy available, and then we should be relegated to the alternative remedy. That there was an order by this court on 6th of August 2019. 6th of August 2019. This point was raised. Of course, at that time, the tribunal was not there. Now, I would like to address, my lord, your lordship, on the question of alternative remedy. And there are a number of petitions pending where I am appearing and I have challenged that, first of all, there is no alternative remedy. This will be my first contention. The second contention would be that even if your lordship hold that there is an alternative remedy, in case of an so-called assessment, I'll call it under section 135 of the Electricity Act 2003. Then also in these cases, since the jurisdiction, the person who has made the assessment, he doesn't have the jurisdiction to make. This will be covered by the exceptions which your lordship knows are there in right from Calcutta discount to my lord Radhakrishnan. These three cases, and the famous case your lordship will know, Whirlpool case. So these are the 2 points on which I will address your lordship.
Radhakrishnan, that Krishnan is spelled differently. Krishnan is spelled differently.
Yes, it's a
Ah.
2021.
Uh-huh.
2021, yes. Now, so therefore, I'll place the alternative remedy first. And I don't know, but then let me place I'll say, because there may be a situation might come during my argument when your lordship would like to refer the matter to a larger bench, because a judgment of the Supreme Court as well as a division bench of this court is involved. There, very interesting point. Of course, to me, it is interesting. Your lordship is doing with 100 cases, so I don't know. The cases may not be very interesting. But I'll place the basic facts which are necessary. But the petitioner carries on business of manufacture and sale of rice. And for that, he needed electricity. And that has been provided by the APDCL. The total connected load is 560 kilowatt. Now, when
Rice mill.
rice, it's a rice. On 12/2/2014, an inspection was carried out in his premises. And the meter and the metering equipments were checked, inspected. Then they find certain grounds. They have made some observations. The seal, everything was intact. Then they have made certain allegations there on the basis of which, only on the basis of which, I'll take your lordships when I go to the marriage. Since I said I'm addressing an alternative remedy. So they have made a assessment under section 135. I'll just show the assessment and then I'll proceed with the alternative remedy.
Because here it says that meter cover right side was broken.
Not meter cover, the seal on the meter cover, both top and right.
I did not get it.
I'll take your lordship. Your lordship, kindly turn to page 30 of the paper book.
Page 30.
30. 30. Is a type copy. I will take your lordship to the Xerox copy, but I'll just place the general remarks, which are clearly written here. As per so-and-so, targeting report so-and-so visited at site. The existing meter system is physically checked. The meter cover seals, so it is sealed, not the meter cover as such. The meter cover seals, top and right sides are found to be broken. It is also observed that there are some yellow color wire coming out from the top of the meter cover. CMRI is taken for computer analysis. It is observed that B phase CT and PT has been interchanged at the metering end, which is rectified. Your lordship will kindly make a mention, which is rectified. They immediately rectified.
No, because if this happens, then there will be a reverse running of meter.
That's right. What I'm saying is this may be a case, but here, if that is the case, they should have stopped the supply and got it checked. By mere mentioning would not do. There has to be some evidence that it is changed. If at all it was there, why should they rectify it? They should immediately stop it. They disconnected the supply later, but they should have immediately done it and not rectified it. And then send the entire CTPT set and the meter to a testing lab to find out whether there was something. Mere mentioning and sensationalizing the issue is not enough. If there is an allegation of theft on the person, they will have to prove it. It will not be, of course, beyond reasonable doubt, but at least there has to be some proof beyond rebuttal, to the extent of rebuttal. Then your lordship will see the connection of secondary CTPT set also checked and found okay. The existing meter is taken into custody for further analysis. So these are the allegations on which, and your lordship, just one thing I want to remove it from your lordship's bind is page 38, the next page. The next page, which is the Xerox copy of the inspection report. If your lordship will see on the right-hand side, serial number 5, seal particulars. Your lordship.
Yes.
Now, there is no remark here, which according to me would show that all seals were intact. And then on the right side, your lordship will see they have taken the meter, put another meter, and your lordship will, if your lordship counts the seal, there are 10 seals on the meter, not one, top and right. There are 10 seals on the meter. And the cabinet box seal.
This serial number 5.
Serial number 5.
Overall MF.
Yes.
Huh.
On the left side, if your lordship will
Yes.
see, seal particulars.
Yes.
So this is the seal which was there on the existing meter. The meter that was there is no remark. Have I been able to make myself?
Yes.
On the right side, they have taken the meter, replaced it with other meter. Your lordship will see new seal particulars. Meter cover, there are 2 seals. Then below that, your lordship will see there are another 2 seals. So 4. Then number 4 is, there is another seal. So 4 seals. Then meter terminal cover, this is 5th seal. Cabinet box, this is 6th. CT secondary, 8, 7 and 8. Optical port 9, and then others, there's something. And so there are 10 seals. Not on the top and two seals only. So if somebody wants to open the meter, they will have to break all the seals. I can show, my lord, with the help of if your lordship so desire. I have made compilation, I'll give it to your lordship. If your lordship will turn to page 142. My lord, these things I've given in so many cases, and those cases are pending on these points only, and I wanted to place this. 142, if your lordship will kindly see.
Yes,
Now, this meter is placed in a cabinet. It could be made of wood, it could be made of steel. Inside, your lordship will see the meter. And these seals are cabinet seals, wired seal and paper seals. These are, of course, meter seals. Then, my lord, the door is closed. And door is closed, and there is a seal which is cabinet seals. Well, unless the cabinet seal is broken, one cannot even open the door and to reach the meter. There is no allegation that cabinet seal was broken. So first and foremost requirement is there must be a broken cabinet seal. Then only somebody can open the gate of the panel or the box to enter the meter. Next page, your lordship will see. These all seals are there, including wire seals as well as the paper seals. And there is not one seal. I'm not, my lord, facing evidence. What I'm trying to substantiate, they themselves have mentioned in their report, inspection report, there's so many seals are there. And I'm just placing the position of the seals. Because if there is only one seal, yes. Then that is broken, I have no defense. If other things are there. Now, on these, I have, my lord, I have challenged this by filing this present writ petition. Now the question is whether there is an alternative remedy. Yes, yes, yes. If your lordship will kindly take up 135 of 2003 Act.
Electricity Act. Act.
Oh, my lord, it is there in the compilation. I'm sorry. It's there in the compilation. Your lordship will turn to
No, I find this book comfortable.
page 4. Okay. Otherwise, all I
No,
have,
it's okay.
I have put everything here. I'll give my book and I will take this. I'll refer to it from here.
E was electricity.
Only thing, my books are marked.
With book, that retentive capacity is more.
Yes. Whoever dishonest,
Just a minute. Me too. That yesterday I was telling you. No, this is for Mr. Chaudhary.
Or-
No, Mr. Chaudhary. The first two lines only.
From the equity port in England.
No, that is why I understand. Mr. Mishra, yesterday we were just discussing theory which I am having. Maybe I am horribly wrong, but there is a thought process. In one of the defamation cases, Mr. Chaudhary, I don't want you to stand on. Please sit down. In one of the defamation cases, I had held. I'll just pass you over this. In this book, I am not having it. The issue was raised in a defamation case that there was an absolute privilege. A statement was made in the plaint alleging making allegations, serious allegations against the defendant. So defendant came in defamation saying that he has been defamed in the plaint. So the defense was taken that no, when I am writing a plaint, I have an absolute privilege. It's a subject matter of evidence. So therefore, when the question of privilege came, I interpret section 2, which is not there, it is repealed. It says that British laws are part of Indian law. So with this deletion, I took a view that once the British laws are no longer there, then the privileges which are there under the common law would not be applicable. Common law principles would not be applicable. Because here every law is a, what you call, a statutory codified law. So therefore, principles of common law will not be attracted wherever there is a codified law. So it is in that context, the point came up that if I am to take cognizance of common law, then I am in my college I have not been taught common law principles, and therefore when British law is not a part of Indian law, why should I go and read the British law? So therefore, I took a view that this law cannot be a part of the Indian law. But there are 6 or 7 judgments, out of which 2 are very famous. This case of Barium Chemicals Company Law Board, where it says that common law is a part of Indian law, and then other is Subramanian Swamy.
Yes.
That also says that common law is inherent in the Indian law. So, but I have my own reservations that that view one has to justify with the legal principles that how it can be a part of Indian law. So it is in that context that this what you call this specific relief act came when we were discussing it. Mr. Chaudhary, can you just pass it over to Mr. Mishra? The introduction. Only 2 lines. Then there was a discussion. Mr. Gautam Vaishya said that no, in India we don't have a codified law for defamation, and therefore common law principles will be attracted. I say that my thought process is that supposing I go and encroach your land, there is no codified law to that effect. So therefore, you come to court alleging or say landlord nuisance, not nuisance, not nuisance is codified. Some other reasons where you want somebody to be evicted or reasons which are not there in the Assam Urban Area Rent Control Act. So if there is no codified law, I can't throw him out. So therefore, I said that it is these two lines which says that for every infringement there is a remedy, and therefore one can come to court even otherwise than taking recourse to the common law principles.
Only, I don't know, often I cannot say, but only thing which comes to my mind is if suppose there is no law, whether the principle of common law would apply.
Principles may apply.
That is the only thing.
The principles will apply when we give damages, award damages. Then we always say that we apply common law principles in awarding
Yes.
damages. But damages, otherwise, when I'm
So far absolute privilege are concerned, I would think it, I mean, just when without thinking, I'm saying, absolute privilege would not be you say anything against anybody in the plain, and then you prove it, until then that man will get defamed without being a party to the suit. If he's a party to the suit, it is all right. He can defend himself and later on sue for damages. But I have my doubt, absolute privilege.
so it was just an academic discussion
Yeah,
yesterday.
I have my thought that.
It was not a what you call prepared debate, but still, I thought to show it to Mr. Chaudhary. I'm sorry to disturb your argument.
In fact, my lord, the object says the common law where there is a infringement, there is a remedy, and the common law principles were there. Then subsequently, my lord, if we read the entire object in reasons, then we find that the law has been codified. So for a specific relief act is concerned, 1877 Act was also there, and the new act has come. So this has also been, my lord, codified.
So that is why my thought process.
There
I
you
don't know whether I'm wrong. I may be horribly wrong. But this is only a thought process.
Yes, my lord. This needs some deep thought. My lord.
No, I wanted the bar to have some, what you call some, since you are there in the bar and now in the helm of the affairs, I think this group discussions in the bar should be encouraged now.
Yes, we are thinking of that also.
That would be very healthy if I get it started. Last time, Mr. Vijay Ansaria gave an offer during the Platinum Jubilee celebrations. He said that he would come to Guwahati, give a skill upgradation, what do you call, meeting for young lawyers, and he would also sponsor the tea and snacks. But
That offer is still open, my lord.
no, but the bar refused. At that point of time, the bar refused. He gave a second offer for the Platinum Jubilee celebrations to encourage young juniors. His offer was to put a award of 1 lakh rupees
Yes.
in a year. And then first young boy would be, boy or girl, advocate, he would be getting 40,000 and 3 second prizes of 20,000 each. So, and his suggestion was that once it will be in the principal seat, then the first prize can go to outlying benches and then come back again in the 4th year to the principal seat. But that also the bar refused. On the ground that there would be a violation of equity. That how can you tag one junior to be better than others? And that was refused. But to my understanding, that was not a correct approach because it is only an incentive to a young junior.
So what happened, my lord, that was very unfortunate. What happened?
No, I'm not on. I'm not on I'm not on whether the decision was right or wrong. It's a collective decision. If there is a collective decision, is always right. If I vote Phulan Devi with 5 lakh vote and make her a MP, the decision of the public is always right. It can't be wrong. But the question is whether it can now again be revisited. So that is the only point,
Yes.
because that would have no personal interest.
Not at all.
If a young member of the bar gets some incentive, because this is one thing I may share with you. I'm sorry, Mr. Mishra, I'm taking some bar time and then deliberating on unnecessary things. I had visited long back. I expressed my this story earlier also. In the Visakhapatnam bar, they have this table where these seniors sit, and the juniors in the morning will come to the tables, and they will just announce that one is going to CGM, one will say I'm going to additional CGM, one will say I'm going to Munsif. So they will just announce in the table, and the seniors will give them roll call. They don't have Hajra system. So first half an hour will be roll call. So the juniors will go and attend. With each roll call, they get 10 or 15 rupees from the senior. And these young boys and girls will go to the court and give the roll call. The roll call will be recorded in the attendance sheet. Whether the witnesses are ready, whether the advocates are ready, whether they will be filing an adjournment. So this is what is done in roll call in half an hour of all the cases. And then these juniors get some incentive. So therefore, at the end of the day, dedication is high. So at the end of the day, junior becomes comfortable. In the morning itself, he or she becomes comfortable because he has got some money, and therefore, this is the incentive their bar is giving to them. The seniors would not go and mention or move an adjournment petition. It will be the juniors who will be doing the roll call. They will go and give it. So that is a good practice I found there. And I'm speaking of about 20, 25 years back, 20 years maybe down the line. So that's how
Nice
I
idea.
continue with Mr. Mishra. I'm sorry, Mr. Mishra, again. Yes,
I'm placing section 135 of them.
yes.
Whoever dishonest taps, makes, or causes to be made any connection with overhead, underground, or underwater lines or cable, or serves wires or service facilities of a licensee or a supplier, as the case may be, or tempers a meter installed or uses a temper meter current reversing transformer loop connections and any other device or method which interferes with accurate and proper registration, calibration, or metering of the electric current, or otherwise results in a manner whereby electricity is stolen or wasted, or damages or destroyed an electric meter, apparatus, equipment, or wire, or causes or allows any one of them to be damaged or destroyed as to interfere with the proper or accurate metering of the electricity, or uses electricity through a tempered meter, or uses electricity for the purpose other than for which the usage of electricity was authorized, so as to abstract or consume or use electricity shall be punished with imprisonment for a term which may extend to 3 years ECB. 3 years with fine or with both. The proviso I'll come later, but I just placed the section 135(1) A to E. And then I'll take your lordships to subsection 1 capital E of section 135A. This deals with the theft of electricity and its consequences. Without prejudice, to the provision of this act, the licensee or supplier, as the case may be, may, upon detection of such theft or electricity, immediately disconnect the supply of electricity, provided that only such officers of licensee or suppliers as authorized for the purpose by the appropriate commission or any other officer of the licensee or supplier, as the case may be, of the ranks higher than the rank so authorized, shall disconnect the supply line of the electricity. Second proviso is provided further that such officer of the licensee or supplier, as the case may be, shall lodge a complaint in writing relating to the commission of such offence in police station having jurisdiction within 24 hours from the time of such disconnection. Provided also that the licensee or supplier, as the case may be, on deposit or payment of assessed amount or electric charges in accordance with the provision of this act, shall, without prejudice to the obligation to lodge complaint as referred to in second proviso of this clause, restore the supply line of the electricity within 48 hours of such deposit or payments. Now, if your lordship kindly see this provision, third proviso. In case a consumer wants his line to be restored, he will have to pay the assessment for the purpose of restoration of his line. There is no question of assessment of any compensation under subsection 3(1) capital A. I may place it again because this is very important. Provided that the licensee or supplier, as the case may be, on deposit or payment of the assessed amount or electricity charges in accordance with the provision of this act, shall, without prejudice to the obligation to lodge a complaint as referred to in second proviso of this clause, restore the supply line of electricity within 48 hours. So this is for the purpose of restoring the connection of the electricity as per this. Now, insofar as the word provision of this act is concerned, it is said, and that's the reason why 126 is brought in, is that there is no provision of the act, provision under the act for making assessment. And this was realized by the central government. And that is how an order was issued in 2005. If your lordship will kindly take the order, then your lordship will have to take this compilation again. Page 16. Page 16.
Yes.
Electricity removal of difficulties order 2005. 16.
Yes.
Whereas the Electricity Act 2003 came in force on 10th of June 2003. And whereas Section 50 of the Act provides that the State Commission shall specify an electricity supply code to provide for recovery of electrical charges, intervals for billing of the electric charges, disconnection of supply of electricity for non-payment thereof, restoration of supply of electricity, tempering distress or damage of electrical plant, electric lines or meter, or supply of line or meter, entry of distribution licenses or any person acting on his behalf for disconnecting supply or removing the meter, entry for replacing, altering or maintaining electric lines or electric plant or meter. And whereas the distribution licensee has expressed the difficulty in controlling theft of electricity and in taking appropriate action in this regard. And whereas enabling the distribution of licensee for taking timely and appropriate action in case of theft or diversion of electricity has become necessary for development of the electricity industry and ensuring supply of electricity to all areas. And whereas taking measures conducive to develop of electricity industry and supply of electricity to all areas are objectives amongst others of the act as stated in the preamble. And whereas the difficulty has arisen in giving effect to the provision of the act in controlling theft of electricity by distribution licensing. Now, therefore, the central government, in exercise of its power conferred under section 183 of the Act, hereby makes the following order in respect of electricity supply code in terms of section 50 of the Act, not inconsistent with the provision of the Act to remove the difficulties. This order may be called Electricity Removal of Difficulties Order 2005. It shall come into force on the day of publication of the official Gazette. Inclusion order 2 says inclusion of measure to control theft of electricity supply in electricity supply code. The electricity supply code as is specified by the State Commission under section 15 of the Act shall also include the following. We are concerned with 1. Method of assessment of electric charges is payable in case of theft of electricity pending adjudication by the appropriate court. This is what we are concerned with. That in case the consumer wants this electricity to be restored, then there has to be an assessment, and for that, method has to be provided. Now, this order was not placed before the Supreme Court judgment which has passed the order which I'll place before you. This order was not placed. Now, for a second, if your lordship can come to section 154. 154 of the Electricity Act.
Section,
154.
yes,
One of their special courts are required to be constituted for this purpose, and your lordship will find in section 153 first. I'll place that. The state government may, for the purpose of providing a speedy trial of offence referred to in section 135 to 140 and section 150, by a notification in the official gazette, constitute as many special courts as may be necessary for such area or areas as may be specified in the notification. So there is a special court which has exclusive jurisdiction to deal with the theft of electricity. Now I'll place section 154(1). Notwithstanding anything contained in the Code of Criminal Procedure 1973, every offence punishable under section 135 to 140 and section 150 shall be triable only by a special court within whose jurisdiction such offences have been committed. So there is exclusive jurisdiction conferred upon the special court for the purpose of trying offences for theft of electricity under section 135 to 140. We are concerned with 135. If your lordship now can come to subsection 5.
yes,
The special court shall determine the civil liability against a consumer or a person in terms of money of theft or in terms of money for theft of energy, which shall not be less than the amount equivalent to 2 times of the tariff rate applicable for the purpose period of 12 months preceding the date of detection of the theft of energy, or exact period of theft if determined. Whichever is less, and the amount of civil liability so determined shall be recovered as if it were a decree of a civil court. 6. In case of civil liability so determined finally, the special court is less than the amount deposited by the consumer or person, the excess amount so deposited by the consumer or person to the board or licensee or the concerned person, as the case may be, shall be refunded by the board or the licensee or the concerned person, as the case may be, within fortnight from the date of communication of the order of the special court, together with interest at prevailing Reserve Bank of India prime lending rate for the purpose of for the period from the date of such deposit till the date of payment. Now you lordship will see the explanation which is important in this case. For the purpose of this section, civil liability means loss or damage incurred by the board or licensee or the concerned person, as the case may be, due to the commission of the offense referred to under section 135 to 40. Now, your lordship has seen the final authority to determine the civil liability is the special court. And that has been referred at page 16 in 2005 order made by the government. This is a statutory order binding. It says that method of assessment of electric charges payable in case of electricity pending adjudication by the appropriate court. So pending this adjudication, for the purpose of restoring the line of a consumer, certain assessments are made. And according to 2005 order, the appropriate commission will incorporate the method of assessment. How the assessment would be made for the purpose of only restoring the line, not determining the civil liability. Now the problem starts with interpretation of section 135A. The argument is, if your lordship will see,
If I have understood you correctly,
yes,
you are saying that not only they will make the assessment,
yes,
but that assessment shall be determined by the special court only.
that subject to, I'm saying subject to determination by the special court.
So that means invariably,
Yes.
Whenever a case of malpractice is there, an assessment is made.
Yes.
The reference to the special tribunal shall be made by the board.
No, FIR is lost.
No, I understand, but the civil liability determination
No,
of,
civil, that also will be determined by the special judge. That is why I said that if a special judge, because he is dealing with the criminal matter, the theft. Therefore, he will also determine the civil liability which will be executed
no,
as
I understand, but who will move the court? Who will be the originator of the proceedings?
FIR, the person who lost 135, your lordship will
So
see.
therefore it will be board.
No. It is the person who, of course, on behalf of the board,
Huh.
but it is the person who detects the theft, who goes for inspection. Your lordship will see second proviso.
No, it's okay. He's a person he's a person designated or authorized.
Yes,
So he moves on behalf of the board.
yes, that's right. So it has, invariably it has to be lost, because if your lordship will see the mandate of the section, it is mandatory when it says shall lodge. If your lordship will kindly see the second proviso once more, provided further that such officer of the licensee or supplier, as the case may be, shall lodge a complaint. And even, my lord, it will be lodged, my lord, without prejudice to whatever compensation is being paid, and then electricity is restored. Third proviso, your lordship will kindly see, provided also that licensee or supplier, as the case may be, on deposit or payment of assessed amount or electricity charges in accordance with the provision of Act shall, kindly see, without prejudice to the obligation to lodge a complaint. So complaint they are obliged to lodge, because they are leveling allegation against a person for theft of electricity. So they are obliged to lodge an FIR. And that is how the special court comes into operation.
This appeal you are reading was section 127.
127, and no, I'm not reading. I'm reading 135 and 154.
154. Oh, I'm sorry.
154
Mhm.
and I have placed 135. 127, I'll come later. 126 and 127. Subsection 5 is your lordship. Yes.
Yes.
Special court is basically a criminal court because it is deciding criminal
It is
offense.
just like land grabbing act, where once you initiate, it will be the civil liability should be determined first, then the criminal liability.
Therefore, it says under subsection 5 that it shall be recovered as if it were a decree of a civil court, the last line of subsection 5. As if it's a decree of a civil court. So I have made two things. One is section 135, 1 capital A, third proviso says for the purpose of restoration, assessment of electric charges will be made, which will be paid, and the electricity will be restored without prejudice to lodging the FIR, the complaint before the police. And so it is not a compensation or civil liability, it is just for the purpose of restoring my connections. If I don't want, it will not be restored. Then the court will decide. Now, one argument which often raised, and it is also there in single judge's order which I'll place, is regarding the opening word of section 135. Dishonesty. Whoever dishonesty. Now it is argued that meaning of dishonesty is given in section 24 of the Indian Penal Code. If your lordship can have Indian Penal Code, he should have given. I'm sorry, he should have given the list of.
No, it's okay. This things I have it handy.
Section 24, if you kindly see. Dishonestly is defined.
Yes.
Whoever does anything with intent of causing wrongful gain to one person or wrongful loss to another person is said to do things dishonestly. Now, the argument is that they will have to prove dishonestly his intentions. It is very difficult to prove. Therefore, the assessment can be made under 126. Now, my submission to that would be that there are two separate liabilities. One is criminal liability. A person committing a criminal act will undergo or will suffer from two consequences. One is he will go to jail or he will be fined for the criminal offense that he has committed. And the second is he will have to pay compensation to the person against whom he has committed these offenses. So these are two different things. 154 and 135 cannot be mixed together. 154, 5 talks of civil liability. It doesn't talk of criminal liability. So, my lord, I'll just give an example. I have a company. I have a manager. Now, the manager, without the knowledge or consent of the company, taps the line. In fact, there is one case pending here. I don't know if you may have heard. McLeod Russell. I did that case. It's still pending. There, the company didn't know. And what the manager was doing, he was tapping the line. And this side, he was showing to the company that the line was not there, so I have used generator. So he was making money in diesel, plus he was doing this. So he was caught. So what I'm saying is, without the knowledge of consumer, if somebody taps and he's caught, he will be punished under 135, he will go to jail. The consumer will not go to jail, but he will have to meet the civil liability. So therefore, if your lordship will see the wording once more with me, 154. 154 explanation says,
Yes,
5 is of course, special court shall determine the civil liability. An explanation, your lordship will see, for the purpose of this section, civil liability means loss or damage incurred by the board or licensee or concerned person as the case may be due to commission of an offense. So once it is shown that there is a theft, irrespective of who is responsible for that theft, the consumer would be liable to compensate. This is my submission. That compensation is the one thing. Civil liability is one thing. Civil liability, in any case, the consumer will have to pay, whether he is responsible for theft or not. And the person who has committed theft, if he is guilty, he will go to jail. And to prove his guilt, dishonesty will come in. 135 will come in. But while determining 135, suppose an accused is acquitted. Consumer will still be liable because once it is proved that theft has happened, whether it is dishonestly or honestly, theft has taken place. As a result of which the licensee has lost some money, has suffered loss. So consumer will have to pay. So these are two different things. It should not be mixed up. Problem arises is 135 is mixed with 154 final. That is how the problem arises in my humble submission. Now, your lordship, I'll show. Invariably, what is happening is that wild allegations are labeled, sometimes without any proof, and this will be a case without proof.
this, your submission with regarding reading of 135 with 154 is criminal liability.
135 is for criminal liability. 154 will be part of 154, 5 and 6 will be for civil liability, which is different altogether.
Uh, 154.5 especially.
But 5 and 6, read with the explanation appended to section 154.
Yes.
Now, my lord, what is happening, I was telling your lordship, invariably there is an assessment made under section 126, even in case of theft of electricity. They will make the assessment, and whether there is proof or there is no proof, assessment is made, there is an allegation of theft of electricity. Under 226, your lordships are elected to go into the facts. Section 145 bars a civil suit. Can you see 145 of the Electricity Act 2000?
Yes, that I'm aware.
Yes. So there is a bar under 145. Therefore, sometimes, my lord, the writ court says that look, there is an allegation. We can't go behind this. We can't see the evidence. There is an allegation. There is an assessment. You go and file an appeal before the appellate authority. Now, appellate authority, my lord, it's like appeal from seizures to seizures' wives. They are all paid by them. So what they give, and sometimes, my lord, what happens is Sometimes this side influences the appellate authority. Then
Out of the two, who is reasonable?
it-
Out of the two, who is reasonable?
Yeah. Yes. So then in some cases, they have come in appeal against appellate authority. So I said, great, I was engaged there. I said, that's great. The turn is turned, table is turned. So, look, that is the problem. That is why I wanted this to be solved. And that's why fortunately, it's before your lordship, and I'll be able to at least praise them, whatever order your lordship thinks, because all said and done, I'm a partisan lawyer appearing for a party. Now, whether 120,
It's a classic, what you call, submission that I can only argue, cannot put it in your head.
no, I'm not saying. What I'm saying is, after all, your lordship is there, your lordship will see both the parties. So far as I'm concerned, I'm appearing for a person. Or wherever I'm appearing for private the consumer. Now, the question is whether an assessment can be made under section
Because this
120.
was an argument made, I have heard it. This is an argument made,
Yeah.
which I have heard.
But there is no decision.
Huh?
Oh, there is no decision.
No, not in this. The statement which I made.
Oh, yes. I see. I remember somebody told me a story. Oh, I don't know if it is there. So that is there. It goes. Now, your lordship can kindly come to page section 126. 126.
Mr. Barba would be a happy man today. Because he does not have to give a what you call a prompt reply.
Half the things are going over my head, my lord. I'm just noting down.
Then somehow you'll have to create an antenna and catch it.
I'm making an endeavor, my lord.
In fact, my lord,
In Hindu law, not in some of the books on Hindu way of life, you will get.
the brothers used to have antenna.
That's what I'm saying. I didn't want to say it, but you will get.
I'll place 120.
And there is some reasoning into it also. There is a reasoning into it. I won't the what you call the smile is just a what you call misnomer, but actually I find reasoning in that theory.
Right.
Uh,
I never kept one. No idea.
No, that's another thing, but there appears to be a very strong good reasons
When the
about that.
those days,
Huh?
they had their own reasonings.
They had their own reasons,
Yes, yes.
and
Of
we
course,
must
for
respect that.
everything, they had their own reasonings. That may not fit in now.
It still fits now.
Well, why I'm saying is it doesn't fit because earlier the education was prerogative of a particular section of the society. I won't say it was not, it didn't percolate down to the others. Now it's not that. So therefore, we are improving, and I hope because those systems not good, I can say that. That to differentiate between human.
No, those are some of the fallouts, but
Yes.
still
Yes.
there are good reasons.
There will be, I'm not saying without, because of course they were very learned people, those persons who made all this. But actually, it's
You are referring to which provision?
126,
126.
because the assessment is made under 126. And because of the provision of 127, appeal lies, this question crops up. Just one will be enough. 126, if on an inspection of any place or premises, or after inspection of the equipment, gadgets, machines, devices, found connected or used, or after inspection of record maintained by any person, the assessing officer comes to the conclusion that such person is indulging in authorized use of electricity, he shall make provisional, he shall provisionally assess to the best of his knowledge the electricity charges payable by such person or any other person benefited by such use. So, number two, it is unauthorized use. And other is, if it is found, then the assessment will be best judgment assessment. Now, best judgment assessment, your lordship knows. It is more or less discretion on the basis of, not absolute discretion, but discretion on the basis of records, some record. Let me place these two, three decisions which are there. I'll just give you. My lord, best judgment assessment, there are two decisions. One is of our Guwahati High Court, Safiullah. Your lordship will take up the compilation. It is at page 43. Page 43. I still find there is a clarity in this judgment. My lord, kindly turn to page 48, paragraph 7. The judgment is by Sarju Prasad. Yes, yes.
Yes.
48. There appears to be still some lurking confusion as to the meaning of expression best judgment assessment. In spite of the fact that the matter has been so often considered and decided by various authorities. Well, this best judgment assessment comes in Income Tax Act, it is defined under section 144, explained further. Best judgment assessment implies that the officer has to weigh the pros and cons of the matter. In other words, he should make an effort to find out materials which can be available and on which he should, to the best of his ability, proceeds to make assessment. The very essence of the matter is justice and fair play. I'm usefully refer in this connection to the decision of Supreme Court, so and so, so and so. So, my lord, all that I'm trying to show that best judgment assessment is based on discretion of the officers by taking into consideration the attending circumstances and whatever evidence is there. The evidence is there, but it is either not admissible or not clinching. But he will take into consideration and make an assessment to the best of his knowledge. My lord, the other case is at page 53 of the same compilation. This is by the Supreme Court, H.M. Yusuf Ali. 7. Okay.
Yes.
Well, relevant would be paragraph 7, 9, and 10. Page 57.
Yes.
Page 57. Before proceeding to examine the contention advanced on behalf of the parties, it is necessary to clarify certain aspects. It may be noted that the first assessment was made by the state six officers primarily on the basis of returns submitted by the SSC. In the proceedings relating to those assessments, sales tax officer relied on books of account of the SSC while making reassessment on the basis of information gathered from the bill book seized. Sales tax officer rejected the account maintained by the SSC as unreliable and assessed the SSC on the basis of its best judgment. The distinction between best judgment assessment and the assessment based on accounts submitted by an SSC must be borne in mind. Sometimes there may be innocent or trivial mistake in the account maintained by the SSC. There may be certain unintended or unimportant omission in those accounts, but yet the accounts may be accepted as genuine and substantially correct. In such cases, assessments are made on the basis of accounts maintained, even though assessing officer may add back to the accounts price of items that might have been omitted to be included in the account. In such a case, the assessment is not best judgment assessment. It is primarily made on the basis of accounts maintained by the SSC. But when assessing officers come to the conclusion that no reliance can be placed upon the account maintained by the SSC, he proceed to assess the SSC on the basis of best judgment assessment. In doing so, he may take such assistance as SSC accounts may afford. He may also rely on other information gathered by him as well as on the surrounding circumstances of the case. The assessment made on the basis of SSC's account and those made on best judgment assessment are totally different types of assessment. Because here comes discretion. And then on 9, 10, my lord, the decisions have been referred, but this is the same effect. Paragraph 9 and 10. Paragraph 9 and 10, then this is, I'll read the quoted portion, my lord, of another Supreme Court judgment. Paragraph 9, the officer is so made an assessment to the best of his judgment as against a person who is default with regard to supplying information. He must not act dishonestly or vindictively or capriciously because he must exercise judgment in the matter. He must make what he believes to be fair estimate of a proper figure of assessment. And for this purpose, he must, their lordship think, be able to take into consideration local knowledge and repute in regard to the SSC's circumstances and his knowledge of the previous return by an SSC and all other matters which he thinks will assist him arriving at a fair and proper estimate. And though there must be necessarily a guesswork in the matter, it must be honest guesswork in the sense too that assessment must be to some extent arbitrary. So this is, my lord, assessment, best judgment assessment is more or less, as I have said, he can take into consideration all the situations and make an assessment to the best of his judgment, to the best of his ability. Now, why this best judgment assessment is given? For that, my lord, I submit that in case of unauthorized use of electricity, there is no measure to check the loss. Because suppose I have a sanction load of 500 kilowatt and I'm using 600 kilowatt, but it is being recorded in the meter. That way, electricity is not, they are not suffering any loss. But I am being benefited in the sense that instead of 500, I'm using 600, for which I could have paid some money. Those things are to be taken into consideration, and on the best judgment assessment, the assessment has to be made. Now, insofar as section 135 of theft of electricity is concerned, the assessments are made on the basis of quantum of energy stolen. This I will show. First, I will place my note. Proviso to section 135. The first two proviso to section 135, which I did not read, I said I'll read it later. I had left it by not extend to 3 years with fine or go below that, provided that in case where the load is abstracted, consumed or used, or attempted abstraction or attempted consumption or attempted use, Lakshmipati, does not exceed 10 kilowatt. So this quantum has to be determined. The fine imposed on the first conviction shall not be less than 3 times the financial gain on account of such theft of electricity. And in the event of second or subsequent conviction, the fine imposed shall not be less than 6 times of the financial gain on account of such theft of electricity. Excess of 10 kilowatt, that severe punishment is severe. The fine imposed on the first conviction shall not be less than 3 times of the financial gain on account of such theft of electricity. And in the event of second or subsequent conviction, the sentence shall be in prison for a term not less than 6 months, for which may extend to 5 years, or with fine not less than 6 times the financial gain on account of such electricity theft of electricity. Provided further that even of second and subsequent conviction, a person where load abstracted, consume or use or attempt to abstract or attempt to consume or attempt to use exceeds 10 kilowatts, such person shall also be debarred from getting any supply of electricity for a period which shall not be less than 3 months but may extend to 2 years, and it shall also be debarred from getting supply of electricity for that period from any other sources of generation. So, your lordship has seen on the basis of quantum of electricity stolen, the punishment is very severe. And civil liability, the explanation, which says, what will be the civil liability? Civil liability will be to the extent of loss suffered due to commission of theft. That is explanation to section 154. Now, therefore, there is no question. There is no question of any best judgment assessment in case of theft of electricity.
Will you please come again?
In case of theft of electricity, the punishment, as I have placed before your lordship, depends on the quantum of electricity stolen. In case it is less than 10 kilowatt, the punishment is different. In case it exceeds 10 kilowatt, the punishment is very severe, to the extent that he may be denied electricity connection for 3 years, up to 3 years. And he may not even be getting it from other sources, assuming that there are 2-3 licensees. He cannot get.
In fact, in earlier times, even for a household generator, we had to take a license.
Yes. Now, I don't know if it is there.
No, it's not there
Not
now.
there. For, I think for heavy, perhaps they will be
No, even
required.
for low, we had a house generator,
Uh-huh.
small generator, but we had a license.
Alright.
There was a permit. given by them, not on that short, but ACB used to give it.
In my childhood, I remember the radio used to have license.
Yes, yes. I still have that, a copy of that license.
Yeah, I think you showed me, yes. Now, your lordship, come back to the civil liability explanation. Explanation to civil liability is how it will be determined. It will be determined on the basis of electricity stolen. I'll just place it once more. Civil liability means damage incurred by the board or licensee as the concerned person, as the case may be, due to commission of offense of theft. So it's directly related to the quantum of energy stolen. And how it will be determined? It is for them to provide, as 2005 order says, by the central government. So therefore, there is no question of making any assessment to the best of knowledge. This is one basic difference between 126 and 135.
Under 135, it can be a best.
No, cannot be. Under 126.
126 can be a best
Can be best.
assessment.
It's mentioned in the in 126 provision itself. The only way is best of judgment because they cannot determine the loss. And there is no loss. Now, this is what the Supreme Court judgment, which I will place, my lord, has not considered this point. The difference between 126 and 135, which has been, my lord, explained by a three-judges bench of the Supreme Court. Now, therefore, my lord, I'm trying to recap what I submitted. Under section 135, there is no question of any assessment on the basis of best judgment assessment, because it will be on the quantum of electricity stolen. Insofar as 126 is concerned, there is actually no loss. Because if I am having 500 kilowatt and I'm using 600, so long it is the electricity consumed is recorded in the meter, there is no loss to the licensee. He's getting the money for the electricity that I'm using, but I'm violating the terms of the agreement on which it is provided to me. So that will be best judgment assessment. Whereas 135, there is no question of best judgment assessment. So this is one difference. The second difference is 135 says whoever dishonestly abstract. So abstract and pilferage are the essential conditions of section 135. So, my lord, the cost of repetition, 126, if your lordship will see, it does not say about abstraction. It only says on inspection of any place or premises or or after inspection of record maintained by any person, the assessing officer come to a conclusion that the person is indulging in unauthorized use of electricity. It's not abstraction. Theft will come when I am using some mechanism which are given under section 135, 1A to E, either using loop or whatever way, to prevent accurate and correct recording of the electricity consumed in the meter. I'm preventing it from being recorded. In that case, my lord, it's a theft of electricity because the licensee is not getting anything. I'm stealing it by preventing its recording in the meter. No such thing are required for unauthorized use of electricity. Now, one explanation which I will say, the Supreme Court missed it. They have noted it, but they have missed the point with all respect. Your Lordship will see 126 and see the explanation. I will show from when I place that judgment, how it is misplaced. The explanation is referred to as if it's part of the section. It's written 126 in bracket 6B3, as if it's part of the section. Your Lordship knows that explanation appended to any provision will be used only for interpreting that provision, not the other provision. On the basis of explanation, the Supreme Court has interpreted section 135. That too against a 3 judges bench of the Supreme Court. Your Lordship will kindly see the explanation. We are concerned with B. For the purpose of this section, Your Lordship will kindly mark, for the purpose of this section means 126. It cannot go beyond. Unauthorized use of electricity means the usage of electricity for the purpose of this section B, unauthorized use of electricity means the usage of electricity by any artificial means or by means not authorized by the concerned person or authority of the licensee, or through a tempered meter. So these are the explanations. Now, what Supreme Court did in that case, through a tempered meter, B3, usage of electricity through a tempered meter. Before I go to 135, Your Lordship will kindly see, it doesn't say of obstruction. It only say by use of a meter, tempered meter. Who has tempered, it doesn't say. Maybe it was supplied by you, it was tempered. And it doesn't say that there is a theft, there is a obstruction or pilferage of electricity, which is not being recorded in the meter. It doesn't say. It only says through a tempered meter. Now, 135, if Your Lordship will see, because similar expression is used in 135. 135, your lordship will come.
Yes.
D. 135 on D.
Yes.
Your lordship will find is uses electricity through a tempered meter.
Yes.
Now, what the Supreme Court, my Lord Honorable Supreme Court did, they did not read the first part. Because D cannot be read by leaving the main stipulation in the section which says whoever dishonestly. So if I have to read D, I will read whoever dishonestly uses electricity through a tempered meter. Dishonestly, as I have shown, means to cause benefit to myself and loss to the licensee. That means I'm abstracting. And not only that, your lordship will see the common one below that. I'll read it like this, below. Whoever dishonestly uses electricity through a tempered meter so as to abstract or consume or use electricity shall be punished with imprisonment for a term which may extend to 3 years. Now, the penal provision which is there so as to abstract cannot be left out from D. Whoever dishonestly cannot be left out. It has to be read while reading D. And if read, it is for the purpose of abstraction. So there is difference between the two expressions, though similar, but used in different contexts. Now, this in fact was raised before, and then as his lordship was, this is called in the Supreme Court now. He was then High Court judge. Same point was raised and he rejected it. He said, no, there is difference. But that was not placed before the subsequent decision of the Supreme Court, Orion matter. I'll be placing that. But then I will go first, my lord, to show what is the use of explanation. When an explanation is attached to any provision, what is its use? My lord, will the first case, I will have 3 cases only, small. The first is Beheta Cooperative. It is, my lord, in the compilation at page 81.
Page.
My lord, it is the reference is AIR 67, Supreme Court 389, page 81 of the compilation. The relevant is at page 85. There, my lord, the interpretation of section 40 of the Cooperative Act was involved. I'll just place, my lord, the relevant one. Paragraph 7 at page 84, my lord. Seventh line from the top, if your lordship will kindly.
Para 7.
Para 7, seventh line in between, in between.
Yes.
Middle. The explanation cannot be read as adding a new head to the categories A to E under section 41A of the dispute, which may be referred to the registrar. Originally, explanation has been added only to make it clear that even if a debt or demand is due, or only point at issue is the liability to pay or manner of enforcement of payment of dispute would come within the purview of the main section. The addition of non-member by amending Act 8 to the first explanation has not enlarged the scope of the main section so as to make it all kinds of dispute between registered society and a non-member cognizable by registrar, thus excluding the jurisdiction of the ordinary courts. Then 9, if your lordship will see, we find ourselves unable to accept this contention. Before the amendment was introduced in 1948, explanation to sections made no mention of non-members, and non-members had to be included in the explanation because of the inclusion of this clause of persons in category E of subsection 1 of section 48. Explanation must be read so as to harmonize with clear up any ambiguity in the main section. In the main section, it should not be so construed as to widen the ambit of the section. The scheme of subsection 1 of section 48 seems to be that certain dispute touching the business of a registered society should not be taken to civil court and made subject matter of prolonged litigation. The legislature took the pain to specify the person whose dispute were to be subject matter of reference to the registrar. Non-members did not come into picture at all. Non-members, other than the officers, agents, servants of the society, do not figure in subclause A to E except surety of the member. By subclause E, only those non-members who had disputes with the financial bank authorized under so and so were made amenable to jurisdiction of the registrar. It was probably thought desirable in the interest of financial bank, which might otherwise be faced with litigation in the civil court in respect of its ordinary day-to-day transactions of the advanced to agriculturists who were non-members, that dispute between society and this class of persons should be quickly and inexpensively adjudicated upon by the respondent. Before amendment of 1948, explanation only served to clear up doubts as to whether dispute was referable to registrar when debt or demand was admitted, and only point at issue was ability to pay or manner enforcement. As already pointed out, this course explanation had to include non-members after insertion of the category in category E and of subsection 1 of 48. The purpose of explanation was never to enlarge the scope of 48 in addition to category to subsection E to that subsection and inclusion of non-member to the explanation. It has limited use, my lord, for the explanation to harmonize the particular provision. It will not have the effect of redrafting or re-legislating the same. Now here, because of the explanation, these explanation, 135 is being interpreted. Now, another decision is, my lord, is at page 88 of the same thing, 88, paragraph 11. 11, page 94. My lord. This is Oblom Electric, 1997, 7 SCC 581. Eleven is at page 94. my lord. Here there was a notification and explanation was added to that notification.
Paragraphs
11,
11.
page 94.
Yes.
It is true that in clause 8 of the explanation, to the notification, the expression materials has been defined to mean goods which are raw materials, components, intermediate products, and consumable used in the manufacture of resultant products and other packing and manufacturing spares to be exported in the resultant product. But the said definition in the explanation has to be read in consonance with the main part of the notification. It is well settled principle that a statutory construction, that explanation must be read so as to harmonize with and clear up ambiguity in the main provision. So main provision to which explanation is attached. Here explanation is given in 130, 126. This cannot be used for interpreting section 130. Now, your lordship, another, just one more, page 96, there is another Supreme Court, Zakia Begum. Page 90, at page 102. Just one line is there, at page 102.
Yes.
Paragraph 19 at page 102. And the two decisions which I have placed before lordship has been reiterated in this. An explanation to a section should normally be read to harmonize with and clear up any ambiguity in the main section, and normally not to widen its ambiguity. So explanation is only for the purpose of explaining what could constitute unauthorized use of electricity. The Supreme Court, my lord, in that judgment, went ahead and said, since similar expressions are used, 135 and 126 say assessment can be made. And it went to, my lord, to the extent of saying that all cases of theft will be covered by the expression unauthorized use. Taking the literal meaning that since it is a theft, it cannot be said to be authorized. You see, literal meaning which the court has taken. Now, the same point.
Again, there are several judgments which says that once the Supreme Court has interpreted it, the High Court cannot take a view which is contrary
No,
and find fault with the order of the Supreme Court.
I'm not saying that. I'm aware of that. What I'm saying is my contention would be, number one, this decision is is contrary to the decision by the 3 judges bench. This is one. Second is the provision of the act has been misinterpreted, because same provision was interpreted there in 3 judges case, Sitaram's case, by 3 judges bench.
I'll just take a break and come.
Let me go, Lordship. Lordship, I requested something, Lordship. Lordship, in item number 3, Lordship, my senior is suffering some internal problems and he has
No, but
operation
these
has
are
already done.
non-adjournment cases. I can't help it.
Lordship, another date may be fixed and the first in the month of August, Lordship.
No, these are top of the list. I can't help it. There are we have compelling reasons to take it up. Yes, Mr. Mishra.
No, my lord, I will come to those two decisions. That will decide my lord. The first decision is Sitaram Rice Mill. This is 2012 to SSC. This your lordship will get at page 62 of the compilation.
This is on that interpretation of 126 and
135.
135.
135. And we've given the relevant paragraphs only.
Yes, paragraph.
Paragraph 22.
Yes.
Now, my lord, before that, your lordship kindly notice that at page 62, that this judgment is delivered by 3 judges there.
Yes, I have seen that.
And the one that I'm questioning rather is by 2 judges bench. Page 63, I'm reading paragraph 22. The relevancy of object and regions for enacting an
Having-
act.
Having noticed your pattern, this is something I have made it a habit.
Here, if your lordship remember, when I was arguing all Assam roller and flour mill case before then Chief Justice Chalmeshwar and Amitav Roy, there was a judgment Srinivasan Trader, which was placed by Additional Solicitor General Mr. Banerjee was campaigning here. And there it says that there is no difference between the cess and the tax, fee and the tax, and it can be nominal. That's what Srinivasan Trader came, where Justice said, my lord said there is a sea change. In 1.5 years, he brought sea change. My lord, with all respect to the division bench was so, my lord, courageous to say that the judgment of Srinivasan Trader is in the teeth of Keval Krishna. Because Keval Krishna said 2/3. I have brought that to show that there is any difficulty in accepting.
No, there is one more from a full bench of Bombay High Court. I think Justice Chagla.
That Chagla, that was 52, page 212, where it says this, that was interpretation of sea
Constitutional bench
custom.
was incorrect. He
Sea,
said,
he went to the extent that the Honorable Supreme Court judges have not applied their minds.
yes, yes.
And what he laid down was accepted in
Was accepted,
1961. I had placed that also in one of the cases.
It was not accepted, but it was not
No, same interpretation was given because it was just
without referring to that.
without referring, correct. Without referring to that. And that Chagla was my favorite when I referred it before Justice Patnaik. I think way back in 1999, he says, hey, I'm not Chagla.
But Mr. Mishra, please give the citation. I have lost that.
I'll give.
52. So,
I think it is, I also don't ask anything. I also don't, I'll give this. I'll give this.
Because this is something I missed out.
Yeah, I'll give this. Let me place this paragraph 22 at page 63. The relevancy of object and regions for enacting an act is a relevant consideration for the court while applying various principles of interpretation of the statute. Normally, the court would not go behind these objects and vision of the act. The discussion of a standing committee to a bill may not be very appropriate per se for tracing the legislative intent, but in given circumstances, it may be of some use to notice some discussions on the legislative intent that is reflected in substantive provision of the act itself. The Standing Committee on Energy 2001, in its discussion said, the committee feels that there is a need to provide safeguard to check misuse of this power by unscrupulous elements. The provision of Section 126 of 2003 Act are self-explanatory. They are intended to cover situations other than the situation specifically covered by under Section 135 of the Act. This would further be a reason of this court to adopt an interpretation which would help attaining the legislative intent. This is very important lines, my lord. Because as I proceed, your lordship will say, we'll see that there is some discrepancy has cropped up, maybe typing mistake or something, I cannot say. Maybe sentences are not good, but that I will explain in this particular judgment itself. And in that context, I hope you remember what Justice Anish Raghuveer used to say. I will not repeat it. Then, so I'm reading it again. The provision of Section 126
I was
of
not there then, but you had made a mention earlier.
yeah, several places I used to make, but now I refrained. The provision of Section 126 of
I
2000.
was after his times. I came to the bar after his times.
Oh,
so,
acha, acha.
92.
I had come from Allahabad that time. Yes, yes, I believe. The provision of section, I'm reading it again, my lord. The provision of 126 of 2003 Act are self-explanatory. They are intended to cover situation other than the situation. Your lordship will kindly mark other than the situation
Yes.
specifically covered under Section 135 of 2003 Act. This would further be a reason for this court to adopt an interpretation which would help in attaining the legislative intent. Then I place 24. It's under the caption distinction between Section 126 and 135. Upon their plain reading and marked differences in contents of Section 126 and 135 of 2003 Act are obvious. They are distinct and different provisions which operate in different fields and have no common premise in law. We have already noticed that Section 126 and 127 of 2003 Act read together constitute a complete code in themselves, covering all relevant considerations for passing of an order of assessment in case which do not fall under Section 135. There can't be any clearer law laid down than this, that the assessment will not cover, assessment under 126 will not cover the assessment under 135. Very emphatic sentences. Then (25) I'm reading. Section 135 of 2003 Act falls under Chapter 14 relating to offense and penalties, and title of the section is theft of electricity. The section opens with the word whoever dishonestly does any or all acts specified under A to E of subsection 1 of Section 135 of the Act so as to abstract or consume or use electricity shall be punishable with imprisonment for a term which may extend to 3 years or with fine or with both. Beside imposition of punishment as specified under these provisions or proviso thereto, subsection 1 capital A of Section 135 of the Act provides that without prejudice to the provision of 2003 Act, the licensee or the supplier, as the case may be, through officers of the rank authorized in this behalf by appropriate commission may immediately disconnect the supply of electricity and even take other measures enumerated under subsection 2 to 4 of the said section. The fine which may be imposed under section 135 of the Act is directly proportionate to the number of conviction and also dependent on extent of load extracted. In contradictions to these provisions, section 126 of the Act would be applicable to the cases where there is no theft of electricity, but the electricity is being consumed in violation of the terms and conditions of supply, leading to malpractices which may squarely fall within the expression unauthorized use of electricity. This assessment of proceedings would commence with the inspection of the premises by an assessing officer and recording of a finding that such consumer is indulging in an unauthorized use of electricity. Then the assessing officer shall provisionally assess to the best of his judgment the electricity charges payable by the consumer, as well as pass provisional assessment in terms of section 126(2) of the 2003 Act. The officer, who is also under obligation to serve notice in terms of section 126(3) of 2003 Act, upon such consumer requiring him to file his objection, if any, against the provisional assessment before final order of assessment is passed within 30 days from the date of service of such provisional assessment. Thereafter, any person served with the order of provisional assessment may accept such assessment, deposit the amount with the licensee within 7 days of the service of such provisional assessment order upon him, or prefer an appeal against the resulted final order under section 127 of the Act. The order of assessment under 126 and the period for which assessment would be passed has to be in terms of subsection 5 and 6 of section 126 of the Act. The explanation to 126 is some significance which shall deal shortly hereinafter. Section 126 Act falls under part 12 and relates to investigation and enforcement and power of the assessing officer to pass the assessment order. Then your lordship will come to 28. Section 135 deals with an offense of theft of electricity and penalty that can be imposed for such theft. This squarely falls within the dimension of the criminal jurisprudence, and mens rea is one of the relevant factors for finding a case of theft. On the contrary, section 126 of 2003 Act does not speak of any criminal intendment and is primarily action remedy available under civil law. It doesn't have features of element which are traceable to criminal concept of mens rea. Thus, it would be clear that expression unauthorized use of electricity under 126 of the Act deals with the case of unauthorized use even in absence of intention. These cases would certainly be different where dishonest abstraction of electricity by any of the methods used under section 135 of the Act. A clear example would be where a consumer used excessive load as against installed load simpliciter. There is violation of terms and conditions of supply. Then the case would fall under 126. On the other hand, where consumer by any means or method is specified under subsection 135A to E has abstracted energy with dishonest intention without authorization, like providing for a direct connection bypassing the installed meter, the case would fall under section 135 of the Act. Therefore, there is a clear distinction between the cases which would fall under 126 of the Act on the one hand and section 135 of the Act on the other. There is no commonality between them in law. They operate in different and distinct fields. The assessing officer has been vested with the power to pass provisional and final order of assessment in case of unauthorized use of electricity, and cases of consumption of electricity beyond contracted load will squarely fall under such power. The legislative intention is to cover cases of malpractice and unauthorized use of electricity, then theft, which is governed by the provision of 35. Well, at one line, if your lordship will see, and then left the theft, it should have been, which is governed by section 135 of the Act. But what is written is, the legislative intent is to cover cases of malpractice and unauthorized use of electricity, and then theft, which is governed by the provision of 135, unless a separate provision of 135. But anyway, this doesn't pose that much. But one paragraph which is of little, sometimes it is relied by the other side. One day it was relied, and when I said, of course, we could not conclude the hearing. Paragraph 49 at page 70. Paragraph 49 at page 70. Yes. 49 I'm replacing. Once the court decides that it has to take a purposive construction as opposed to textual construction, then legislative purpose sought to be achieved by such interpretation has to be kept in mind. We have already indicated that keeping in view of the legislative scheme, my lord, as that scheme is given in paragraph 22. The provision of 2003 Act, it will be appropriate to adopt an approach of purposive construction on the facts of this case. We have also indicated above that provision of 126 are intended to cover the cases. Now here, over and above cases which would be specifically covered by the provision of section 135. This is interpreted that no, 135 is included. 135 and 126 is included, is referred together. Have I been able to make myself clear? It should have been, my lord, we have indicated the provision of 126 are intended to cover cases. In place of over and above, it should have been other than. Because what is indicated in paragraph 22 to 30, which I have just placed, it says that two provisions are entirely separate, different. So over and above is that maybe a typing mistake, according to me. It should be other than, as they have stated, my lord, and I have read earlier in paragraph specifically, if your lordship will see. 24, if your lordship sees specifically. First 22, the last three lines, 22 at page 63. Because they say over and above means so 35 also, or 35 also. But the court says we have referred to discussed above, as discussed above. So what was discussed above is this, paragraph 22 at page 63.
What is the tax matter? Which is that tax matter where I just interpreted a 9 judgment order and said that this was a typing error and therefore all orders should be rectified.
That I don't remember, but there is one case where the two constitution bench decisions on the,
Those were corrected by what you call a smaller bench by saying it was a typing error which is crept in and therefore.
yes, because in the context, if it appears it's a typing matter, it can either be ignored because what was that?
It's a tax matter.
Justice Rohinton Nariman. There were two cases which interpreted the word omission, and the two constitution bench, I think remember Royla and another, I don't remember, Royla Corporation and another Cane Sugar or something, constitution which says that omission would mean it will not be saved by section 6 of the General Clauses Act. That was held to be per incurium in Fiver Brand case 2015 by Justice Rohinton Nariman. Two judges bench.
There's a tax matter.
That
Well-
I don't remember. So therefore, my lord, your lordship will kindly, I just want to make a point that in paragraph 49 says, we have also indicated above. What is indicated above? Just 22, your lordship will come at page 63. 3 lines, last 3 lines. The provision of 126 are self-explanatory. They are intended to cover situation other than the situation specifically. So this is what has been stated. Similarly, 24, last line, it says, we have already noticed section 126 and 127 read together constitute complete code in themselves, covering all relevant considerations for passing an order of assessment in cases which do not fall under 130. So this is what has been held. So it cannot be interpreted that in 49 says that over and above they will cases they will consider this also, which will include 135. This is the interpretation which was given in earlier occasion. Now, from this, my lord, Sitaram case, the 3 judges bench, it is made absolutely clear that there is difference between section 126 and 135 of the Act. Now I'll come to Orion Metal case, which is the well, on page 71. This is the judgment. And your lordship see page 71. This is by 2 judges bench. Justice R. Bhanumati and S. R. Subhas Reddy. Judgment is by Justice Reddy. May I please?
Just one.
My lord, 11. Paragraph 11 to 14.
Yes.
Now, page 78, paragraph 11 starts it. At perusal of the provision and on giving a co-joint reading of the same, it appears to us that after an inspection of any place or any premises of any consumer, when the assessing officer comes to a conclusion that consumer is indulging in unauthorized use of electricity, the provisional assessment to the best of his judgment is to be made in accordance with section 126(1) of the Act. And such provisional assessment shall be served upon the person in occupation of the premises. After giving an opportunity to file objection to the provisional assessment, assessing officer is empowered to pass a final order of assessment assessing the loss of energy on account of unauthorized use of electricity. The unauthorized use of electricity is defined under section 126(6)(b) of the Act. This is where the problem arose. Your Lordship will see 126(6) of the Act. There is nothing like B. B, which is being referred, is the explanation. Subsection 1 is just 6 is stands alone. It doesn't have any appendix.
Yes.
So this is a mistake. The unauthorized use of electricity is defined. It is not defined. There is an explanation. Under section 126(6)(b) of the Act, it is clear from a aforesaid definition that unauthorized use of electricity means usage of electricity by artificial means or by means not authorized by the concerned person or authority or licensee or through a tempered meter or for purpose other than which usage of electricity was authorized, and for premises or area other than those for which the supply of electricity was authorized. Then I go to B. It is clear from reading of section, the Lordship will again mark it, section 126(6)(b)(3) of the Act. Now, my Lord, with all respect, as an explanation cannot be read as section. There is no section. This judgment is par incurium on the face of it. It is clear from reading of section 126(6)(b)(3) of the Act that instances of use of energy through a tempered meter is included in the definition of unauthorized use of electricity. If that be so, there is no reason for excluding the power of authority for making assessment under 126 of the case to assess the loss of energy which electricity used through a tempered meter. There is no loss. 120 explanation doesn't say there is a loss. All instances of, now this is fantastic, my lord, with all respect. All instances of unauthorized use of electricity energy may not amount to theft of electricity within the meaning of 135 of the Act. But at the same time, the theft of electricity which is covered by section 135 would fall within the definition of unauthorized use of electricity. One question that I ask myself, where is the abstraction? Dishonest abstraction under 126. There is no abstraction at all, as the larger bench has held in Sitaram's case. As per section 135(1)(a), the next page I'm coming to, of the Act, without prejudice to other provision of the Act, the licensee or the supplier, as the case may be, upon detection of theft, is empowered to disconnect the supply immediately. There is no such power under 126, madam, to immediately disconnect. There is no such power. The power is only in case of theft. Further, as per third proviso to subsection 135(1)(a) of the Act, the licensee or supplier, as the case may be, on deposit or payment of assessed amount of electricity charges without prejudice to obligation to lodge complaint, can restore the power supply within 48 hours. That is clear that authorities under the Act are empowered to make provisional assessment invoking power under 126. How come, I mean, I'm just at my wit's end. How come 126(1) comes in? Will it be, theft will be assessed on the basis of best judgment assessment? Or it will be assessed on the basis of the quantum of energy stolen? Thus, it is clear that authorities under the Act are empowered to make provisional and final assessment by invoking power under 126 of the Act, even in case where electricity is unauthorized use by way of theft. When the consumer deposits the assessed amount and the supplier restore the power supply, the assessed amount referred to in the proviso relates to assessment under 126(1). There is apparent distinction between 126 and 135. 126 forms part of a scheme which authorizes the electric supply to ascertain electricity to act of unauthorized use of electricity, whereas 135 deals with offense of theft. He is bound to have indulged himself in the Act mentioned in clauses A to E of subsection so and so, so and so. My lord, once their lordship has held this, then they should have, my lord, there is no question of 135 being similar to 126. Because they say the sine qua non is that he must indulge himself in mention in any of the clauses under A to E. Or A to E says whoever dishonestly abstract the energy so as to prevent its recording in the meter, correct and accurate recording in the meter, he will be liable under 135. And he'll not be heard of for unauthorized use of electricity. Further, it is clear from 154 of the Act, which prescribes procedure and power for a special court, that a special court is empowered to convict the consumer and impose sentence of imprisonment. The special court in cases where criminal complaint is lodged is also empowered to determine civil liabilities under section 154(5) and 154(6). In case of civil liability so determined, the special court is less than the amount deposited by the consumer will be, he's referring to the sections, shall be refunded to the licensee or concerned person as the case may be. Merely because the special court is empowered to determine civil liability under 155(4) of the Act, in cases where complaint is lodged, it cannot be said that there is no power conferred on the authority to make assessment, provisional assessment under 126. So, my lord, the cost of repetition, I'm only saying, the assessments are can be made different way. Under 135, it is the amount of energy stolen, quantum of energy stolen rather, and there it is best judgment assessment. Now he says 135 best judgment assessment. There's no question of best judgment assessment. There has to be assessment of the to how much quantum is stolen. And I will show, my lord, I'll come back to this, but I'll just, for the time being, I'll just show, my lord, we are covered, my lord, here we are governed by 2007 supply order, supply code. That is, my lord, I have given at page 11, if your lordship will kindly turn to, then I'll go back to the page 11. Your lordship will kindly see at page 14. Clause 5.A.4.4.
You are referring this for what purpose?
Because we are governed by this. It is mentioned here how the assessment will be made in case of theft of electricity. In case of theft of electricity.
Just a moment. This on interpretation of 126 and 135.
Yes.
You have relied on that 2012 2 SCC.
Yes.
And then you are again relying on this, you are referring to this Manu. The page, this compilation page.
70.
Huh.
Now, this is judgment
they-
which is
they-
contrary, which is
No,
against me.
No, it's okay.
Ah.
You are relying on any other judgment on this point.
No, on this point, I am not.
Okay.
I'm just, I will end here.
No, means
This-
I'm, since
yeah.
I'm
Yeah, this is the
going
only
to a
judgment.
different
Here are the
sequence.
two judgments.
Since I'm referring to new sequence, I'm
Yes,
just
yes.
meeting a point.
My lord, your lordship will see page 14. Because now the supply order. Yes, the supply order. Yeah, now the supply code is of 2017, but at the relevant time, 2014 would apply. So I'm referring from there. First, I will refer page 14, then I will show the comedy of error which has been made here. The lordship will turn to page 14 first. 5.A.4.4. The last
Six.
clause.
Shakespeare.
Yes, last clause of 14. The full, the Orient metal and this is full of that. 14, your lordship will see the last. When consumer indulges. When the
Yes.
consumer indulges in theft of electricity, the officer authorized in this behalf by the government of Assam may, without prejudice to other rights, will assess quantum of electricity loss on the basis of assessed consumption of detected category, etc., etc. So the basis is quantum of energy lost. So just previous page, your lordship will come to 13. 5.8.4. And this was in 2004, my lord, when the Orient metal had not come. This supply code was made. I'll place this at page 13. Under the caption, method of assessment of electricity charges payable in case of theft pending adjudication by appropriate court. You know, she got it. When a consumer is found indulging in malpractice with regard to use of electricity and use of device to commit theft of electricity, the authorized officer under section 126 may, without prejudice to any other action, may take against such consumer, ask him to pay compensation. Now, this is against the statutory provision, against the Act 135, where it says it has 135 read with 154, quantum of energy. And they also say in subsequent clauses, but here they have said this. So that's why I'm saying this is nothing but comedy of error. Now I come back to the Orient metal, two paragraphs are more, which I will refer. What has surprised me, in paragraph 13, they are referring to Sitaram case. And they are quoting, my lord, paragraph 29, which I have placed, page 79. Paragraph 13. In case of Executive Engineer, Southern Electricity Supply Company, Orissa Limited, and others versus Sitaram Rice Mill. Now, this Sitaram Rice Mill, my lord, I have already placed before lordship. It is at page 62 of the compilation. Reported in 2012 SCC 108, this court has considered the scope and explanation of section. Again, my lord, there is some problem. Section 126B4 of the Act. not section, explanation. In the aforesaid case, as there was no allegation of theft, this court held that consumption in excess of sanctioned contract load comes within the meaning of unauthorized use of electricity as per explanation so and so of section 126 of the Electricity Act, drawing a distinction between 126 and 135 in paragraph 29 and 61 of the aforesaid judgment read as under. Then they have quoted 29. I have already placed with your lordship.
But in after two lines, they have explained, explanation D of B4.
Where?
Para 13 you were reading.
Yes. Yes.
Earlier they said B4, then after two lines they say, as
That
per explanation B of,
Explanation, no, explanation to section 26B4 again wrong. The explanation to section 126. An explanation is clause B. There are two explanations, clause A and clause B.
here is written B, as the second line after 126 B4,
My lord,
as per explanation B,
yes, yes,
4
they-
of section 126.
yes, because they are quoting from there. Yeah, they have written here.
Ah.
But then here your lordship will see section and then they are writing, saying here. That excess of contract load, so it's a drawing distinction between that was because by the meaning of unauthorized use of as per the explanation B, yeah, they said so. Because it was said in the Sitaram rice mill case. They are saying from there, but then they are not correcting themselves because there is, as I have pointed out, there is difference between the provision of the act and explanation to the provision. There's vast difference. Those three decisions I have placed there. 29, should I read it again?
No,
Then 61. 61, I have not placed, so I'll read it. 61 at page 80. This is also from Sitaram. Undoubtedly, use of electricity cannot be restricted to the stated clause under explanation has to be given a wider meaning so as to cover cases of violation of terms and conditions of supply. Because they were dealing with 126. But has to be given wider meaning so as to cover cases of violation of terms and conditions of the supply and the regulation and provision of 2003 Act governing such supply. Unauthorized use of electricity itself is an expression which would in its plain reading take within its scope all misuse of electricity, even malpractices adopting using electricity. It is difficult to restrict these expressions and limit its application to categories stated in the explanation. It is indisputably that electricity supply to consumer is restricted and controlled by the terms and conditions of supply, the regulations framed and the provision of section 2003 Act. Well, what was the argument? If your lordship will just take 123, section 126 for a second. The argument in this case was it was a case of violation of the agreement and they were assessed under 126. So the argument was that violation of the agreement would not fall under 126. An explanation they have shown, that there is no mention is made that that the expression unauthorized use of electricity would like encompass in itself the violation of act. So therefore, even if there is a violation of agreement, it will not amount to unauthorized use. That is what was explained in 61. He said, no, it has to be expanded. All unauthorized use will come in because you are getting your supply on the basis of your agreement. And if you violate the terms, it will definitely be unauthorized.
unauthorized used.
Because you have not been authorized. So that is what was said. Now, having quoted that, the ultimate paragraph 14 at page 80. We do not find ourselves any valid reason for making distinction as made by the High Court applying 126. From the scheme of the Act, it appears that after inspection, team notices unauthorized use of electricity by tempering the meter, the authority can disconnect the supply immediately, make immediate assessment of loss of energy by invoking power under 126. I'll stop here. They want, what their lordship has said, that the assessment will be made for assessment for loss of energy under 126. Whether 126 provides, it says best judgment assessment for unauthorized use because there is no loss, actual loss. The judgment is per inferior. Absolutely without application of mind, with all respect. I'll read again. From scheme of the act, it appears that after inspection, team notices unauthorized use of energy by tempering the meter, the authorities can disconnect the power supply immediately and can make immediate assessment for loss of energy by invoking power under 126(1) of the Act. The term unauthorized use of energy is wide connotation. There may be cases of unauthorized use of electricity not amounting to theft, which are cases with exceeding the sanction load, using electricity in the premises where the use is not authorized, but at the same time, when there is an allegation of unauthorized use of energy by tempering meters, such unauthorized use of electricity include theft under 135. In order to constitute theft, there has to be illegal obstruction, unlawful obstruction. And there is not even a whisper that 135 requires, that there has to be obstruction or pilferage of electricity by using any of the method used enumerated under section 135(1)(a) to E. Not a whisper. The power conferred on the authorities making assessment under 126 of the Act and power to determine civil liability under 154(5) cannot be said to be parallel to each other. In this regard, we are of the view that the High Court has committed an error in recording the finding that both proceedings cannot operate parallelly. In a given case where there is no theft of energy amounting to unauthorized use of electricity, in such case, no complaint of theft can be lodged under section so-and-so. In such cases, for loss of energy on account of unauthorized use, energy not amounting to is always open to authority to assess the loss of energy by resorting to power under 126. In cases where allegation of unauthorized use of energy amounting to theft, in such cases, apart from assessing the proceeding under 126, a complaint can also be lodged alleging theft of energy as defined under so-and-so. In such case, the special court is empowered to determine civil liability under section 154(5). On determination of civil liability by a special court, the excess amount, if any, deposited by the petitioner is to be refunded to the consumer. It is settled principle that to prove guilty of an accused in criminal proceeding, authorities have to prove case beyond reasonable doubt. The element of mens rea is also established. On the other hand, such strict proof is not necessary for assessing liability under 126(1). Now, Millard, where is the question of making an assessment under 154 of the civil liability that mens rea is required? 154 doesn't say. That is required for the punishing person under 135, not for making assessment of the civil liability. And if it was so, there would not have been any need for the central government to make the 2005 order. That 2005 order is not produced here. If theft can be made, if for theft assessment can be made under 126, there would not have been any necessity for the central government to come out with the removal of difficulty order 2005, which I have placed before you.
They could have just made an assessment.
We just made an assessment because the biggest difference between the two is under 135, there has to be a dishonest use of theft of electricity, abstraction and pilferage of electricity, number one. Number two, the assessment has to be based on quantum of energy stolen. In case of 126, it is, my lord, there is no actual loss. 126, I have repeatedly said, my lord, I'm sorry, but there is no actual loss. It's unauthorized use. So when there is no actual loss, where is the question of making an assessment, my lord, under 126 on base judgment assessment? So now they will forget about quantum of energy stolen and they will make assessment with best of judgment. It's impermissible, totally, my lord. So there is basic difference between 126 and 135. And therefore, there is no question of making any assessment for the purpose as given in 126. The assessment can be made only under the third proviso to section 135(1)(a) of the Act, for the purpose of restoring the electricity connection. Now, how the consumers are being prejudiced. First, we have no alternative but to come to the writ court because we cannot go to the civil court. This is one. Second, under 135, the final authority is the special court. Even Orient Metal has not disputed that. They said that whatever amount is paid will be deducted when the amount is determined by the special judge. So final authority to decide civil liability is the special court. Now, what is happening is, there is an allegation of theft, as I will show when I go to the merit of the case, I will show, my lord, there is not an iota of evidence. Rather, evidence on record suggests otherwise. Their own record will suggest otherwise. For example, they say that we have tested, the error is 0% error. 0% error means under 1956 rules, which applies by virtue of section 183, still applies. By virtue of that, there is a presumption that if the error is 0, the meter will be deemed to be correct. But they will make an assessment. And they will ask us, you pay 50% and go to the appellate authority. Appellate authority will decide. We will come to the court. The court will say, look, there is a disputed question. Where do we go? Where the consumer will go? People are suffering. They are being made to pay. This is, my lord, the problem which, because of the Orient Metal, this problem is being faced. Now, once your lordship decides, if your lordship decides that no, the appeal would lie, then your lordship will have to think this is a matter of 2014, whether your lordship will relegate us there. This is one. Second, I will then argue that there is no jurisdiction, there is a jurisdictional error, because your lordship will appreciate that in order to make an assessment, and even under 126, there has to be, if at all theft is included there, there has to be prima facie at least evidence to show that yes. Their mere saying would not be. They say, my lord, that the 2 seals are broken. There is no explanation. There are 10 seals. How anybody can enter the meter? The cabinet box seal is intact. There is no allegation that cabinet seal is broken. There is absolutely no allegation to that issue. Then, my lord,
But those wires would not grow
Yeah.
like a beard.
that's right. Now 2 wires are coming out. One yellow color wire or something is coming out. Some wire, we use expression. Now they say that, is it not their duty to send the meter to the lab for testing? The law insists that every licensee should have an accredited lab. They should have sent from where it has come, how it has come, because everything is sealed. Meter cannot be opened. And meter, these meters, especially these digital meters,
Unless it grows like a beard.
yes. So there is no test. And on top of it, your own document, they have replied saying that the error is 0. So that means the meter is correctly functioning. On this, can I be saddled with liability, my lord? In 2014, 33 lakhs on rice mill, this liability 34 lakhs has been saddled. No proof. You have to prove. Show the lab report.
We'll continue to.
Well, so far as the merit your lordship would hear, or after this only thing your lordship will.
I think we will, since it is come for hearing, we'll take up everything.
No,
You want to do it today or some other day?
oh, tired. I get little tired. But then there will be problem. I can do it next week on Thursday only. On Thursday. Tuesday I will try, if your lordship may. Otherwise Thursday. I have a matter for Chief Justice, which is going to take time. So I don't know whether I'll be able to do it on Tuesday. Your lordship may keep it on Tuesday.
If we make it Thursday, we'll accommodate you.
Then Thursday I'll continue Thursday.
Next Thursday. 27th. Mathematical.
It is 19, the Chagra's judgment, I've got 1955 Bombay,
Just a moment.
AIR.
Just a moment. Nineteen,
AIR 1955 Bombay,
yes.
113. Mohandas Ishwar Das.
Mohandas Issudas.
Yes.
I'll just record it because for some reason this is closing down. Yeah, 1955,
Bombay,
yes,
113.
113.
Three.
But Mr. D.K. Mishra Senior. But Mr. D.K. Mishra Ranit, Senior Counsel, assisted by Mr. PJ Bora, Counsel for the petitioner. His argument remains inconclusive. List again on 27 27/7/2023. Next one, Mr. A. Barwal, and standing counsel for APDCL is present. State is also there? No, okay.
Item 2,
on the views on call for the petitioner. Mr. K. Gogoi, an additional senior government advocate.
So I am appearing
Yes,
on
what-
all the respondents.
All the respondents. Next, para. In brief, comma, the case of the petitioner. Is that he has a ration shop at Kakopata, K-O-P-A-T-H, in Tinsukia district. Full stop. On, after the inspection was made at his ration shop on 15/5/2010, comma, show cause notice dated 22/6/2010 was issued to the petitioner, comma, which contains 5 major allegations pertaining to short supply of food articles, comma, diversion of food articles to stock market, black market, and making false entries in the stock register. Containing, not 5, make it major allegations like so and so, comma, etc. So, the reply of the petitioner was found unsatisfactory, and accordingly the TDS license of the petitioner was not renewed. And thereafter by an order dated 30/11/2010, comma, the assistant director, comma, food and civil supplies, comma, Tinsukia, cancelled the PDS license of the petitioner. Full stop. The petitioner referred an appeal before the Deputy Commissioner, comma, Tinsukia, and the said appellate authority, after giving an opportunity of hearing to the petitioner, comma, by order dated 26/9/2013, comma, upheld the order dated 30/11/2010, by which license was cancelled. And the appeal was rejected. Full stop. Thereafter, the matter was taken up in appeal before the Commissioner, comma, Aparasam Division, and the said authority, and the said appellate authority, comma, by his order dated 17/10/2013, it rejected the appeal filed by the petitioner. Next, brother. The learned additional senior government advocate had submitted that the petitioner was put to notice about the allegations contained against him, and the allegations that were available against him, against the petitioner. So, referring to the order dated 26/9/2013, passed by the Deputy Commissioner Tinsukia, it was submitted that the petitioner was a habitual offender and had regularly diverted the PDS commodities allotted to him in black market. And therefore, the learned additional senior government advocate has supported the order of cancellation of the PDS license of the petitioner. Next. Be that as it may, it appears that the petitioner was absent when the matter was previously listed on 29/11/2018. And also on 30, and also when the matter was listed on 31/8/2022. And again, today the petitioner is absent on call. So therefore, the court is of the considered opinion that the petitioner is disinclined to prosecute this matter, and accordingly this petition stands dismissed for the first order. Defeat for non-prosecution.
Item 3.
May it please your lordship. Lordship, the original counsel engaged in this case is not present.
I am aware he is indisposed. But we are under compelling circumstances, we have to take up the hearing and dispose it out. These are old matters
Okay, ma'am.
which is now being questioned. The pendency of the old matters are being questioned now.
So my lord, in this matter, my lord, the National Highway Authority acquired the land of the petitioner for setting out boundaries and intended lines of work. And my lord, for such acquisition, the petitioner lost his burial land and also things attached to that land, my lord. But after that, the National Highway Authority did not use that land, but due to such acquisition, non-acquisition, the petitioner faced extended loss, my lord. Then my lord, on then petitioner filed a regular civil suit on 19/09/2013, where my lord, that civil court ordered for re-verification. Then my lord, sir, re-verification was done in the presence of the contractors of National Highway Authority. And after such re-verification, my lord, the district magistrate of Haflong determine a compensation amount that is 35,19,407 rupees. But my lord, later on the National Highway Authority rejected the said bills and failed to make such compensation.
Yes. So, Barwa,
My lord, my pleasure, your lordship.
here this land acquisition compensation were determined by the appellate authority.
My lord, here over.
Thereafter, you can't. It will not be open to you to sit and appeal over the appellate order.
This is actually what happened, my lord. The land which petitioners have belonging. We have acquired the land. Due compensation has been paid. Thereafter, they have filed an application before the district magistrate, commissioner, magistrate, under section 3G, 3B, 3G and the provision of NSA. And thereafter, it was reassessed, this amount. Now, basically, the lordship will go by the representative. In our affidavit, we have stated everything, my lord. And in number there. according to us, my lord, this land in question is for uh, compensation sort. That is beyond ROW, that is right of way. That we stand, we took on our affidavit, my lord.
That is the only reason.
It's the region and thereafter, my lord. Thereafter, of course, I worry your lordship because senior council is not there. I have
You
to
have
assist-
accepted the determination. After that, you can't question it.
Yeah.
You should have filed a writ petition.
Yes, there
You
would
have
have
you have
been,
accepted the, you have accepted the.
we have not accepted. my lord. That is
calculation.
why we have not accepted only due to this region, they are filing this region. Now I'll take your lordship because as he is not there, I have to properly assist lordship here. Lordship may go, but it's been challenged. It is lordship may produce. They're challenging Annexure K. The lordship got it right. This is here. K. Here, according to us, lordship made it. It's been-
Please continue.
Here, my lord, why this one? In compliance, this submission of bill compensation regarding Mr. So-and-so kindly. So in compliance with code direction in connection in case number 19 of 2000 and dated 19 to 2020 joint verification was done in 25th and 26th February 2014 for re-verification.
No, can you do it? After adjudication, can you do it? After 3G adjudication, can you do it?
No, here this after 3G already we have paid the amount. Due compensation was paid and they have given NOC for that. This due already NOC was given by them, those after taking payment. Now,
See, that is okay. Somebody is waiting for that. That itself is a, it can't be a ground because to refuse adjudication. You see what happens if, let us say there is a decree of 100 rupees against X.
Hmm.
The, what you call the judgment debtor is paying rupees 10. He has accepted it. Given a no objection for 10, will it dilute the decree?
no. But here the question is coming, our stand is on where this land is beyond ROW.
That
This,
is not acceptable. You challenge that order. Once this order has attained finality, then you can't question it. You can't be the appellate authority over 3G.
here only. One,
No, unfortunately, you see, you are the government, a part of the government. You can very well amend your land acquisition, what you call this, National Highways Act, and say that after appeal, we will adjudicate what is right, what is wrong.
no, here your lordship no parents. This affidavit of government also. 2007. Here, lordship.
No, does anything wipe off the judgment of, do you have anything which wipes off the judgment of the appellate authority?
No, they are not, it cannot be said appellate authority also. Because if we go by law, as law terms, they are in a, this cannot be the authority is the arbitrator.
Who has given this order?
This is given by this civil code, civil suit it was given. By civil code,
Show me that.
yes. Resistance is required. $75 million. Page 75.
75, yes.
75 onward. That is that. Lordship. Because here. I was not hoping that I have to argue make petition. Trial court below. Final order. Trial court, that is application, that is trial court. Annex R is copy of final order dated 19 to 2014. Past date means that is 96 to 100. The problem now. We are also not thinking. Okay, judgment, what is this? Judgment deciding, judgment.
It's that judgment starts at page 80.
Copy of petition. 59 copy of petition. Copy of order, is number tribunal. But I could below and it's 1995. That is 80 is the reference.
Yes, you have
Yes,
petition
96 actually,
96.
96. Copy passed by, that is page annexure is,
No, in one of the orders, it is said that the new compensation committee would be constituted. Was it constituted?
here Lordship will go back. Which one they have taken in different time of the occasion. The observation and friendship and check.
In the order at page 20, page 88, the compensation board was reconstituted
Yes. this
because
is
it
lot
came to a
now.
finding that the CBI inquiry could not be made and therefore this inquiry was reconstituted.
Lordship, after this order, this 101, it is cleared, 101.
(101).
Page. Okay, you are an enemy.
You see, just come to page 111. Here it says that there was a joint verification conducted by the representative NHA and land revenue and landowner on so and so. So this is something which you have admitted. It's okay, I'll close it, I'll dispose it off. If I have to read it, I can read it. And pass others.
I learned the lordship from my edition. They have filed government, competent office file affidavit. Affidavit in this regard, response number 7. And reply to that I have given. My reply may be perused below only. This-
I'll do it. If I have to read it myself, I'll read it.
Then I'll do it. I'll read it now.
Just do it then.
Then
Complete
I'll
the
do
order. Complete that part.
Yes, I'll complete.
Hmm.
Now, this regarding entire matters to come by this affidavit. Affidavit is filed
By whom?
by the secretary, revenue,
Respondent number
6 and 7.
7.
6 and 7.
7, but 7 is signed.
When did you file it?
22, 7, 16.
22, 7/16.
Five and 6 months.
And our bidding included, very small affidavit. Because I have replied on that point. You hear me, Lord?
Just, I'm not finding that. Twenty-seven 16.
22, 7. One Vipul Singh
Sengyong.
Wing.
Yes.
Here, Lordship may. This one, 4. paragraph
Yes.
4. That which passage of the time of owing to delay execution of NS 54, the land in question was forcibly enforced and occupied by the petitioner, alleging that they had not been paid compensation for some of the jirats and standing properties located within the acquired lands. As the petitioner did not allow construction of the NS 54E, so no any damage of the land and standing properties of the land has been made hitherto. It may be pertinent to mention here that both the Jaikumar Haplang, husband of the petitioner one, that is Timothy Lesson Haplangbar, and Shri Pradeep Haplangbar had already received their dues of compensation amounting to rupees 20,94,875 and rupees 3,84,930 930 only recently from NSA for damages of their patta land and civil structure likely to be ensued due to construction of NS 54. But Sri Ranendra Haplangbar did not receive the dues of compensation entailing yet setback of the construction NS 54E. But thereafter the petitioner had filed a suit with the additional district magistrate Dimahasa Haplang 1999-2000 for damage of land standing properties like to ensue due to construction of NS 54E. Finally, the additional district magistrate passed an order for joint re-verification of the subject affected land and properties on 19/2014 in Miss case number 19 of 2013. 6. The person to the aforesaid order joint verification was conducted by the representative of NSA, Revenue Department, landowners, other local people on 25th and 26th February 2014. On the joint verification, it was found out that the claim of the petitioner are partially correct in as much as some jirach and other standing properties were found to be left out and not included during the previous joint verification and assessment competition held in the year 2005 due to oversight. It would be pertinent to mention here that as was evident from the fact that as per joint verification report of the land of Shri Ranendra Haplang Bar held on 28/2005 valuable Gamadi mature tree numbering 30 were listed in the joint verification report, but the same were not included in the compensation bill as the result of no payment was made hitherto. Further, many other jirachs located within the actual alignment of NS 54E affected land of the petitioners were found to be left out during previous joint verification due to oversight so far as reflected in the joint verification held on 26 February 2014. Furthermore, the homestead land and the residents of the petitioner were affected due to construction of NS 54E, accepting the land of the land of the Pradeep Haplang by additional land of the other petitioner such as Srimati Lesson Haplang by Ravinda Haplang were acquired during the last joint verification of the NS 54. Thereafter, detailed report of the joint verification was submitted to the district magistrate Dimahasa Haplang on 3/2014 and accordingly determined the compensation as per the consent status of the land question submitted the bill 35,19,407 only before the Deputy General Manager Project NSA PIU so and so dated thesis which had been already received by NSA authority with full particulars assessment separately petitioner who had affected past and present status of the land standing properties belonging to property. But the NSA had rejected the bill for compensation, returned the same to the council by letter dated 26/6/2014, that is impugned. Being aggrieved by the aforesaid action NSA, the petitioner has filed this petition that the deponent beg to state that the aforesaid petition has been filed seeking interim NSA to deposit the amount compensation for land which were acquired for construction of National Highway in Dimahasa district in terms of joint verification report. The deponent begs to state that 12/1/2014 when the matter was listed before the Honorable Court, the learned counsel for the petitioner submitted the additional land was acquired and further compensation assessed for additional land by revenue authorities of the Dimahasa Autonomous Council on 3/6/2014. Under such circumstances, the refusal of NSA authority to deposit additional amount though impugned letter 26/14 is wholly unjustified. However, the council for the NSA contended the additional land was not acquired for construction since alignment for the proposed land was fixed much earlier and the same cannot be altered, which might require requisition of further land. Accordingly, Honorable Court observed that to clear the controversy whether additional land was required for highway project, the stand of Dima Hasao Council was needed. That it is to be reiterated that clarification herein as reported as per order dated 19/2/2014 passed by the learned additional district magistrate Dima Hasao Haplang in miscellaneous case on
Mr. Barwa, to make it short, you see, you come to page para 6 of which you are reading.
6 of my.
Para 6 which you are reading right now. Para 6,
Ah.
come to para 6. You got it?
Got it.
Now, about 7 or 8 lines from above, you will find it is also pertinent to mention that there was an evidence from the fact that as per joint verification report of the land of Sri Ranendra Haflong Bar on 28/2005, valuable Gamari mature trees number so and so 30 were not included in the compensation bill.
Yes,
You are reading it?
yes.
No,
I'm
if
reading.
you are distracted, then don't
No,
read
no,
it.
I'm reading.
I said I'll read
I'm
out my
reading.
pass orders.
Then I'm reading.
So therefore, this is a statement of 28/2/2005. Correct?
Mm.
Come to your own affidavit at annexure C, page 24. Affidavit in reply of yours,
Affidavit reply.
uh, against respondent 6 and 7.
That is against para 6. Now,
You please see what I'm referring to, whether it is para 6 or not, I don't rehearse and come. I don't make it by heart and come. You read para page 24 of your affidavit. Affidavit in reply to affidavit of the government. Your affidavit in reply against the affidavit filed by the government.
yes.
Come to page 24.
Twenty-four.
Yes, you are there.
Yes.
Now please read this.
Annexure C.
Yes,
Ranendra Haplang Bar, so and so, have no objection in relinquish my allotted, occupied, converted under AK periodic quota 48. That is situated Malingpur village, so and so. Have 4 and less only concerned Department of Concern Sporty I to put and the 28/2005.
28/2005.
Mm.
So now you see here on 28/2005, you make a joint verification, you admit that 30 trees are left out. And after that, he signs it. And now you are saying that he has relinquished his right. He did not relinquish his right. You made an assessment in respect of the land. He says my trees are left out. On 28/2, you do a verification. You don't contest the verification. You do it. There's a finding of fact that 33s are left out. And therefore he signs it relinquishment. He does it in good faith.
So here, my lord, if we understood. No,
You understand whatever you want to, but here it is apparent. Government affidavit says 28/5 joint verification were done.
yes.
You don't dispute that the joint verification was done on 28/5. So on 28/5, when he finds that his grievances are addressed, he signs it. What is
Maybe.
wrong in that? So your non-payment is wrong. You see, somebody goes to civil court. You also don't challenge the jurisdiction. You accept the orders passed.
That is a
On
point.
19/2/2005, there is an order about re-verification that you accept. 19/2 order is in your writ petition. You accept that contention. You go and have the joint verification made. And when it comes to payment, you say that I don't pay. 28/2, you admit the joint verification. And he signs it on good faith. That okay, when the officers are there, the DC, deputy commissioners, representatives are there, autonomous council representatives are there. So he signs it on that day, on the verification day.
Oh, that part
Then-
is correct. 28 here also,
Then
22 also
you make
correct.
the payment. If you want to challenge it, you challenge it. That procedure was never challenged by you.
That is, I would have also gone
No, no.
before the arbiter.
If you want to challenge it, you challenge it.
Actually,
You admit to a procedure.
yes, it is fault on our part also, I duly admit of record, because we'd have also gone, that time would have a challenge because jurisdiction issue. Because recently one case, similar issue, that has been set aside by this honorable court. But we have not challenged this one here. That is also correct, but
No, no,
here,
you see, let me understand your proposition. Number one, you have notified and taken over, what you call, land is acquired by National Highway. As against quantum, appeal can be filed under 3G, correct? But what if somebody says that you have not, what you call, these RATs are not assessed, and therefore, please do a re-verification. So question of challenge of the quantum will never come. This is a question of preliminary, the primary, what you call, assessment.
or correct, this, because once we did not object it, thereby, now we are little, because we have challenged this one, because this magistrate civil suit is not entitled. He would have gone for either arbitrator would have gone for arbitrator. He has not gone arbitrator. We also accept, not accepted it. So that part I am fully agreeing on that point.
Can you make comment? If you want to challenge, you do it. But this
Or
has to be allowed.
now here also we'd have, in this case also we'd have gone to arbitrator, my lord. This again, this also, there is option, would have been option for us, for arbitrator.
My lord, petitioner is not agreed by the order of district magistrate, my lord. Why they go to the arbitrator, my lord? My lord, the order of the district magistrate is on behalf of the petitioner.
No, that is okay. He did not challenge the jurisdiction, but otherwise, Mr. Barua is right. The question of jurisdiction is there. He is otherwise right on merit. But since he had only participated, therefore we are against
That is
the respondent. Otherwise, the law is heavily against you. Heard, Miss
Please, J. Bezbora.
J. Besbarwa, counsel for the petitioners. As also heard. Mr. K. Goel and CGC appearing for respondent number 1.
And for 2T.
No, one you can appear.
One actually, nowadays. is
CGC.
Separated,
Okay,
that is right.
okay. CGC for 1.
This is there. Earlier we used to.
Mr. C. Barwa, and then standing also for NHAI appearing for respondent numbers
2, 3, 4, 5, Miller.
2, 3, 4, and 5. For 6 will be appearing.
6 and 7.
6 and
7.
No.
Okay. Mr. A. Khanikar, and standing counsel for NCL's Autonomous Council representing respondent number 6, 7,
6
and 9.
8 and 9 will come.
Okay. Mr. M, as well as Mr. M. Chettiar and government advocate appearing for respondent 8 and 9. Agreed by the non-payment of the land acquisition bill.
Down to 2 rupees, Miller, that is. 35 lakhs.
Page 111. not again. The land acquisition compensation bill for an amount of rupees 35,19,407 in connection with prepared pursuant to orders passed in Miss case number 19 of 2023. The present writ petition has been filed under Article 226 of the Constitution of India. As for the case projected in this writ petition is that the land of the petitioners was acquired for the purpose of construction of the extension of national highway.
That is
On the,
54 in bracket E,
pardon me,
National Highway number 54
NH 54
in
capital
bracket
E
E.
within bracket E.
E.
Okay. Full stop. The petitioners had projected that there was anomaly in the assessment of compensation as certain trees forming part of ZIRATs were not assessed. And accordingly, the petitioners approached the court of the Deputy Commissioner, Haflong, and a
Miss case
proceeding
number was
being Miss case number 19 of 2013 was registered. In connection with this said proceeding, and order was passed on 19/2/2014 by the additional district magistrate, Dimahasa district, for conducting a re-verification regarding assessment, regarding assessing of compensation. Full stop. Pursuant to the said order, a joint re-verification was held on 25/2/2014 and 26/2/2014. And this detailed report of joint re-verification was submitted to the district magistrate Dimahasa, Haflong, on 3/3/2014. Thereafter, the Secretary in charge revenue, NCL's Autonomous Council, Haflong, and competent authority, NH-54 within bracket capital E, LA Works, etc. Full stop, submitted a compensation bill in respect of the three petitioners hearing for a sum of rupees 35,19,407. Full stop. However, by the impugned communication dated 26/6/2014, the bill for compensation raised pursuant to Miss case number 19 of 2013 was returned back by the manager within bracket tech PECH bracket closed NHAI Full stop. The learning standing also for the NHAI representing respondent numbers 2 to 4 had submitted that if the petitioners were aggrieved by the assessment made by the assessment of compensation made by the competent authority, the only remedy available to the petitioner was to file an appeal under section 3 capital G of the National Highways Act, which year? 56, 1956. And accordingly, it was not open to the petitioners to approach the court of the deputy commissioner and to have the assessment re-adjudicated through the federal authority. Accordingly, it is submitted that the deputy commissioner and the additional deputy commissioner who was in session, who was adjudicating this case number 19 of 2014, were acting 13, were acting without jurisdiction.
At that time, my lord, Haplang in 2013, and the judiciary was not separate from the executive, my lord. So, deputy commissioner has the power or jurisdiction to.
I'm adjudicating in your favor. Don't open your mouth because I may turn at any point of time. Because otherwise you don't have, the authority was acting without jurisdiction. Correct. First of all. Next para. Consider the rate petition, affidavit in opposition filed by the respondent numbers 2 to 4,
And also by 6, 7.
affidavit in opposition on behalf of respondent number 5. Additional affidavit filed by the petitioners.
That is by 6 and 7 million.
I'll come to it, don't worry. Affidavit filed by the respondent numbers 6 and 7. Affidavit in reply filed by respondent numbers 2, 3, and 4 against affidavit filed by respondent numbers 6 and 7. Next, it is not in dispute that National Highways Act, National Highways Act. Just pass over that book.
It will.
Hey, it will be.
It will.
It's okay. It's okay. We have got it.
Achha.
Got it. It is not in dispute that under the provisions of subsection 5 of section 3G of the National Highways Act, if the amount determined by the competent authority under subsection within bracket 1 or subsection within bracket 2 is not acceptable to either of the parties, the agreed parties are at liberty to move the nominated arbitrator who is appointed by the central government. In the present case in hand, the central government, by way of a gazette notification dated,
That is regarding appointment, my lord.
Huh.
It is 31st December 2001.
2001,
Oh, my lord, yes.
had appointed the commissioner,
Uh,
comma,
For divisional commissioner for
divisional commissioner.
Hills and Barak Valley division dispute. His
Hills and-
lordship will
Hills and-
get in 145 days.
Hills and Barak Valley Division as the arbitrator
Arbitrage.
within the in terms of,
Lordship got in
So-
145, it is there.
it's
Yes.
okay, I'm accepting your statement.
Yes,
As per section 3G within bracket 5 of the National Highways Act 1956. Full stop. Nonetheless, despite the said statutory provision, it appears that the National Highways Authority of India, i.e. respondent numbers 2, 3, and 4, had participated in the proceedings of Miss Case number 19 of 2013. The order dated 19/2/2014 passed in the said proceedings is extracted below. Page 96. The said order has attained finality without any challenge to the legality of the said order. Pursuant to the said directions, a joint re-verification was conducted by the NHAI representatives, the Revenue Department of the NCL's Autonomous Council, and the affected persons. And they had accepted anomalies in the computation of compensation as some zirat, including land and trees and civil structures of the affected persons were left out in the acquisition process. Full stop. Moreover, it appears from the contents of the communication dated 3/3/2014 by the Secretary and capital R full stop O full stop E full stop comma NCL's Autonomous Council, addressed to the Additional District Magistrate Dima Sao, Haflong, that in order to straighten the road, comma, 35-meter stretch of land of the land of the petitioner was also taken over for was also taken over. Full stop. Thereafter, comma, as already indicated above, the secretary, comma, in charge revenue, comma, NCL's Autonomous Council, comma, Haflong, and competent authority, NH-54 within bracket E, capital E, comma, LA Works, comma, etc., full stop, comma, prepared and issued a bill dated 3/6/2014. Addressed to the general manager within bracket tech and project director, NHAI, comma, PIU, comma, Nagaon, for a sum of rupees 35, 19, 407. Full stop. Next para, as already indicated above, comma, the joint re-verification of land was conducted on 28 2014. As per stand taken in the affidavit in opposition filed by respondent number 6 and 7, comma, mature Gamari trees, GAMARI, Gamari trees numbering 30 were found to be were found in the joint verification report to be not included in the compensation bill. And that it was also found that the homestead and residence of the petition of the petitioners were affected due to construction of NH-54E and accordingly while the competent authority, i.e. the competent authority had raised the bill dated 3/6/2014 for rupees 35, 19, 407, satisfied with the re-verification conducted on 28/2/2005, on the same day, i.e. on 28/2/2005, the petitioners herein signed their no objection for relinquishment of their occupied land. in respect of their land. Next, therefore, it appears that the no objection by the petitioners in respect of relinquishment of their land is not a standalone document, but the said relinquishment having been done on 28/2/2005 was on the same day when the joint re-verification of the land of the petitioners was made. It is not in dispute that the items which are left out in during assessment during earlier assessment were included in the re-verification assessment done on 28/2/2005 in the presence of the petitioners as well as the representatives of the NHAI. Therefore, the respondent numbers 2, 3, and 4, through their officers having participated in the verification process, is bound by the principles of estoppel from taking a U-turn and disowning the original, the re-verification assessment for which bill dated 3/6/2014 was raised by the competent authority, NH 54 capital E. Next paragraph. As the competent authority, NH-54 capital E within bracket capital E was the original authority to assess the quantum of land acquisition compensation, in the event the NHAI is aggrieved by such assessment, the respondent numbers 2, 3, and 4 were at liberty to assail the assessment under the provisions of Section 5 of Section capital 3G of the National Highways Act. Full stop. The said procedure was not taken recourse to by the National Highways Authority of India, i.e. respondent numbers 2, 3, and 4. So therefore, it could is of the considered opinion that the impugn order bearing number capital NHAI oblique NGN oblique LA oblique N full stop C full stop Hills oblique 10964 dated 26/6/2014 issued by the manager within bracket tech NHAI. His respondent number
Yeah, take 4, my lord.
bracket respondent number 4, thereby rejecting and returning the bill along with forwarding. So you just write bill number Page 111. Capital REV oblique S oblique 66 oblique ROE oblique 201 P-2014 dated 3/6/2014, submitted by forwarding letter number the same, REV oblique S oblique 66 oblique ROE oblique 2013-14, now oblique 2714-18 dated 3/6/2014. It is not sustainable and the same is set aside and quashed. The secretary, in charge revenue, the Dima South district is directed to resubmit the bill to the competent authority of to the competent authority of the respondent numbers 2, 3, and 4 for payment of a land acquisition compensation to the petitioners. This bill will go to whom? Number 3
Actually,
or
my lord,
4?
here, it will go to first to, no, the general manager will place 3, it will go to 3, 4, then it will forward it to.
No, 4 maybe there may not be there. If this project is complete, the project manager will not be there.
The project director is there, here come and project director is written, my lord. Though it is a, because I don't put a, this Nagaon project is not there, there is a merge with it, Guwahati, but anyhow, if it is written, then also I'll clarify that.
We'll say to send it to number 3 and they will send it to the competent authority.
Actually, this bill, because project concerned, project director is to prepare. Thereafter, it will go to RO office, the general office, because this is come under
No,
project.
no. You see, my order must be implementable. So therefore, what I will say that the bill will be sent to number 3. They will send it to their competent authority.
Here, for satisfaction, my lord. General procedure, I'm telling, because
No, I
this bill
understand.
will be, this
No, supposing this
competent
number,
authority, my lord, competent authority will send to concerned project director.
no,
Yeah,
who
this
is
just
the
one number.
project director?
Project director is 4, general manager and project director, lordship may get it. Project director is still there,
Project director.
project
Okay.
director. Now,
Okay.
lordship may
Okay,
say
the
project director,
Okay, the
PIO,
president.
uh,
Send to the project director,
only.
NHAI.
General manager, technical and project director.
No, he may not be there now.
He may not be there, but project director is there. That will be looking to.
I
Because
don't,
he
I
was,
don't want the order to be non-implementable.
yes, that
It
is
should
I'm
be
telling.
implementable order.
This earlier what happened, he did may not be.
It's okay, I'm
available.
accepting your submission.
My lord,
Now it is project director.
project director, because though it is written, my lord, for only clarification for further, because though it is written in Nagaon project, when it was there, Nagaon project was there. Now Nagaon project is merged with Guwahati. That is why my
Okay.
submission may be recorded
Okay, okay.
this way.
Just say, shall be sent to the.
At the time of filing, it was
Shall be sent to the
PIO,
competent
Nagaon.
authority, full stop. Next para, at this stage, the lowest standing council for the
NSA.
NHAI, on the pinpointed query of the court, has submitted that the respondent number 4 authority may not exist at this moment as the project implementation unit, Nagaon, has been merged with project implementation unit Guwahati.
Guwahati.
And therefore, he submits that the bill can be raised and sent to the project director,
Guwahati direct.
NHAI, Guwahati.
Guwahati direct.
Full stop. In view of the next, in view of this submission made by the Standing Council for NHAI, the Secretary, IC Revenue with NCS Autonomous Council within bracket respond number 7 shall now raise the bill to the authority as mentioned herein before. Next para, the reparation stands allowed on terms as indicated above. The next para, the parties are left to bear their own cost.
Obliged. We are expecting same, Lord. Yesterday, I was speaking to same order because very beginning I cannot say. This is our fault, our part. we did not raise our voice.
No, you see, I have plenty of time. The question is, you may not have time.
My lord, if at the very beginning I submit, I cannot surrender also being standing counsel.
Okay,
Well,
I
I left
don't-
that.
I can pay. Item 4.
My lord, before my learned friend starts, your lordship will find that the United Bank is a
Is no longer
Lord,
there.
defunct body. So
It's
therefore,
okay. We will take, what you call, instead of, you see, we are under immense pressure for disposal of this
My lord.
14 item.
no, I
But we
don't
can-
have
no,
any
no.
problem.
No, what I can do is that I'll record your submission
Yes.
that this is no longer there. And the new bank will be now
Punjab National.
Punjab National Bank.
Fine.
So we'll just take a note of that and
Yes, yes.
try to
that-
rectify it.
Yes. I'm ready otherwise, my lord, because it's my duty, otherwise. your
No, no,
lordship
you
would
are,
have
you are
said,
absolutely, I
Well-
took note of that, but since we are under immense pressure to dispose of these
Yes,
matters,
yes.
The question
that is why in top of the list.
Whether my learned friend will still be appearing in the case or not, that has been the question.
They will appear. Because that instructions will now has already flown.
No, that I'm not very sure. That's why I'm asking that. The issue is very short, my lord. The Indian Oil Corporation is before your lordship. Selling an order of the recovery officer of the Debt Recovery Tribunal by which he has rejected the
So
petition.
who are you?
I'm the Indian Oil Corporation Limited.
No, no, means you are the beneficial owner of that property.
I am the beneficial owner of that property, but I was not a party to the proceeding. And only when a notice of auction was put in the newspaper, we came to know about it. Then approached the recovery officer for stay of the auction. And that has been rejected.
No, correct. You see, just before you start, I'm just asking you a question. Supposing you have a better right in respect to the land because of your agreement. This petrol pump is, the land is otherwise owned by others and
Yes. They have been
they
leased
give
out,
us, they give a right,
leased out.
they
by registered
lease out to
companies.
you. Now,
So subsequent to the lease, the owner of the land has mortgaged the property, falsely claiming, showing him to be the distributor of Indian Oil Corporation, and has mortgaged the land, and he could not pay the entire amount, and that's why there was a proceeding by the bank initiated in the Debt Recovery Tribunal. And
but
my
then
lord,
once you have a lease, what you can do is alternatively, what you call, since a third party right has now been created by way of an auction.
yes. No, auction has not taken place by way of the my
It's
lord
not
certificate.
taken place.
It has
Then
not
you
come.
can, you can offer the amount and now with some interest and that can be what do you call that can be one way of looking at it. Second is that if you take a plea that the lease right is paramount and therefore the loan taken was fraudulent, then it is for you to go to the civil court and have your rights adjudicated. Now, under the amended DRT Act, that plea can also be taken up before the Debt
Civil-
Recovery Tribunal. Because if I take that view, because that is preliminary view I was taking, subject to what you say. Because if the Debt Recovery Tribunal is competent to go into those aspects, then we relegate you to the Debt Recovery Tribunal.
My lord, yes, that is one, my lord, one aspect of looking at the things, my lord. We had seen the notice of auction. We know that the property is ours by way of a lease, long-term lease. And the loan that has been obtained and the mortgage that has been created is far, my lord, later. Our, my lord, lease is anterior in point of time. So accordingly, we filed an application under Rule 18 of the procedure rules to the recovery officer saying that there is a lease and therefore that is priority in time, and therefore this could not have been done, and fraud has been committed by
No,
claiming.
there's another way of looking at it.
Right.
I was anticipating this. So you see, there's another way of looking at it. The right of a lessee can only be to retain the lease, nothing more. So even if somebody else becomes the owner of the property, your right to the lease would be there, but subject to one provision in the transfer property which says that charges, if any, on the mortgage property gets liquidated on the property being auctioned. But you see, the lease is with the third party, that is with you.
Yes, my lord.
So you'll have a right to enforce that lease, because if anything which is attached to that land has created a third party right in so far as you are concerned, in your favor,
Yes.
you can from the whoever becomes the owner of the property, you can enforce your lease against them.
Now here, my lord, the auction is in not only, my lord, in respect of the land, along with the, my lord, properties we have there, it's a retail outlet, my lord. All the properties, those are put to auction.
No, if you can satisfy the debt recovery officer to exclude those which are not part of the leasehold land, because otherwise, what you see from the definition of land, anything attached to the earth, and there are judgments which says that even if there's a attached to earth on nut and bolt, that also becomes a part of the land.
Yes.
So if you can convince the recovery officer and exclude those, because that is your ownership. I understand that.
Now, my lord, the question before your worship, my lord, that I want to put is, my lord, that I having, my lord, not being made in a party in the, my lord, original application, and my lord, now having approached the tribunal, the recovery officer, because, my lord, that is another aspect, whether the recovery officer is a tribunal or not, my lord. And he has rejected on two grounds. First ground is that I could have gone to the civil court to establish my right, number one. And number two, there are two grounds he has given. The second ground he has taken is, my lord, the impugn order your worship finds at page 71. There are
Page?
two, page 71.
71.
The grounds are at page 73. Last paragraph, findings. Heard both the sides on the petition number such and such, the petitioner has not preferred any appeal against the order of attachment or auction under section 30 of the DRT Act 1993. The certificate was issued to recover the dues of the applicant bank. So unless any stay order passed by the appellate tribunal, appellate authority, recovery proceeding cannot be stayed. This is one ground. The other ground here stated is that I could have gone to the civil court. I have not gone to the civil. These are the
No,
two.
because at that point of time, the DRT Act did not permit you to go to civil court.
Right.
Sorry, at that point of time, you could have gone to civil court to declare it a fraud. But now, after the amendment of that Act,
Yes.
Recovery Act,
Yes, ma'am.
what is the new name now?
No, my lord, the Recovery of Debts and Bankruptcy Act 1990.
And Bankruptcy Act.
Yes.
So under this act now, the recovery officer or the tribunal can take up those issues also.
Then, my lord, your worship may direct that, man. I think that will be a very fair order.
Yes, Mr. Datta.
My lord, before that, your lordship kindly see the lease deed at page 32. I'll just take your lordship to that.
Page 32. Yes,
Your lordship will find it was registered on 31/3/2004.
31/3/2004, yes.
Now, the mortgage is at page 43. Your lordship kindly see that.
Prior to that,
Yes. At page 43, that is on 16/3/2002. So therefore, my lord, the bank has a better right.
no, you.
And in terms of that, my lord, I will take your lordships to a provision under 31B of the Recovery of Debt Act. 31B, if your lordship has the book.
My lord, lease deed is at page 32, my lord.
32 years. That is 2 years after this
Yes,
mortgage.
my lord, can I take your lordship? to
Just a moment. That is sometime in 2002. And this mortgage is in 2004.
Oh,
Dates I will not remember. Recovery of debts.
My lord, I'm sorry, my lord, I have to find out. The lease, original lease was in 1995, my lord. I just trying to look at the.
that is unregistered. They
Yeah,
have
it was
put the-
registered on 31/3/2004.
Prior to that, my lord, there was an unregistered, say, deed.
That would not,
That will not come.
But that can be, my lord, considered for collateral purposes. Unregistered deed. That can, my lord, considered for collateral purposes. Collateral purposes to show that, my lord, we have to.
If the value is beyond 100,
no. The bar of physical capital will not be ready in evidence.
yes.
I'll just clarify that position. Transfer of Property Act. Registration Act,
Section 47 of Registration Act.
47, it will not be ready in evidence. You have that Registration Act. Okay, I'll just pass it on. Just give me 2 minutes.
There is the decision of the Supreme Court, my lord, of course, I have not brought it, 2011-14 SCC. Recently,
What does it say?
unregistered lease deed has no effect, but it can be used for collateral purposes. That is what is said, my lord.
Collateral purpose, that's a different issue, ma'am.
The collateral purpose here is that to show that, my lord, we are in the possession of the land, and the, my lord, the retail outfit was running from 1995.
No, it's okay. But you see, once a mortgage is created prior to that, that will extinguish it. You're right. I just wanted this shortcut for a different reason, Mr. Datta.
Well,
So that, you see, I don't make any observation as to the rights of the parties.
yes,
And then both of you go with a clean slate before the recovery officer. But if I have to adjudicate,
well, I understand.
that may, because you see, there are two ways of looking at it
Yes.
in this aspect also. Number one, when I'm relegating you, normally I should not give my opinion.
Yes,
But if I'm giving an opinion, then the Supreme Court now recent judgment says that you should have disposed it of.
right.
Yes.
Only thing for a moment,
Huh.
I'd like to take your lordship.
Just a moment. Mr. Chaudhary was citing me some judgment.
Well,
11-14 SCC, page 66. And I will go.
Registration Act. Huh. It was 49, 27.
SCC online is on under repair, therefore they will be.
Huh?
SCC online is under. my lord-
Under repair, okay.
We could not get the.
No, it's okay, I'll have it, because I use the offline version. Can you see 49?
No document required by section 17. or by any provision of the transfer of property 1882 to be registered shall affect any immovable property comprised therein or confer any power to adopt it or be received as evidence of any transaction affecting such property or conferring such power.
Just wait here for a time being.
Yes.
That is first part. Number one, it shall not be read in evidence in respect of that transaction. Correct. Now, second part, please read the next part.
Be received in evidence or any transaction affecting such property or conferring such power unless it has been registered, provided that an unregistered document affecting immovable property and required by the act of the transfer act or the transfer of property act 1882 to be registered may be received as evidence of a contract in a suit for specific performance under chapter 2 of the Specific Relief Act 1877
Next.
or as evidence of any collateral transaction not required to be affected by registered document.
So therefore, if there is a transaction of money, that is not required to be registered. So therefore, collateral purpose would be the amount of money. Supposing you say that I have given that amount of money, that will be a collateral transaction not requiring registration. That can be read in evidence. But the transaction of the lease itself, being the subject matter, that comes within the first part where I stopped you earlier. It will not be received in evidence in respect of that transaction.
But I define that, my lord, I am paying rent for that.
No, that is okay.
That is the
That is
the
okay.
second part of it.
But second part, so far as rent is concerned, you can still go ahead. You want to seek a protection as a landlord and tenant, you can still go ahead. That is a collateral transaction.
Yes.
So that is my understanding. Because before you are placing 2014, this is what I'm trying to read.
Your worship is correct. Your worship is correct.
So that
Here
is
is the
why.
case, my lord, the bank has taken out mortgage a property without verifying the land. That is how they have done it. Well, now they are taking technical pleas in the affidavit.
You know the very sad part. As a lawyer, then earlier, and I was with one of my clients. We are going either to Delhi or Calcutta for some work. And this, just when we move out of the airport, few young boys and girls, they come and they say that, please give us your visiting card. We will approve you for a credit card. So twice or thrice it happened. I never gave my visiting card. But at one point of time, my client, same client, he is now a family member. He said that, well, why did you give a card? I said, why waste money? Because I don't want to spend my card on that. Because I don't want a credit card. He said, no, you will get it back. You just give it to them and they'll return it to you. Very honorably. So I gave my card. He said, oh, lawyer, no, please take it back. You don't, you're not a first class customer. So he returned back. And then I became angry, said, how can you bank treat a lawyer like that? I was very agitated. But when I came back to Guwahati, I visited the bank and the bank manager, maybe someone like Mr. Datta, could give me a cup of tea and convince me that lawyers we don't trust. So therefore, I think only lawyers' land would be verified by them.
Here, my lord, the client, he has, my lord, described himself, my lord, the borrower has described himself as the dealer of IOC. He's not the dealer of IOC. That has also not been verified by the bank. Anyway, my
That's
lord,
okay.
since your lordship is not going into the merits of
No,
the
I
case,
just say what Mr. Datta is trying to convince
No, my lord, I just like to highlight 31B
of
of the Recovery of Debt and Bankruptcy Act.
31B. These are new provisions I am not acquainted.
New provision.
Priority to secured creditors.
2016 amendment, my lord.
Huh.
Notwithstanding anything contained in any other law for the time being in force, the rights of secured creditors to realize secured debt due and payable to them by sale of assets over which security interest is created shall have priority and shall be paid in priority over all other debt and government dues, including revenues, taxes, seizures, and rates due to the central government, state government, or local authority. For the purposes of this section, it is hereby clarified that on that part is not required. Now, my lord, so far the priority is concerned, the bank will have the first priority, even, my lord, if there is a debt relating to central government or state government. And in order to support my argument, my lord, I am placing a recent decision of the appeals court, where, my lord, appeals court has also upheld that.
It says that even prior to tax.
Yes, in excise case, my lord, Mahindra Bank. No, that your lordship will find. My lord, the
No,
central excise and
I'm
customs.
trying to, just a moment, I'm trying to.
This provision is.
Just a moment.
My lord.
You have a Transport Property Act.
Yes, my lord.
Please come to section 57.
Sorry, my lord, it's not, no problem.
You have that?
No, my lord.
Yeah, Mr. Das. Mr. Chaudhary, Mr. Chaudhary, no. Mr. Chaudhary. (57) says discharge of all encumbrance by court sale. Therefore, you see, without going into the technicalities right now, you see, even if there is, there are provisions which says that you can deposit the money.
Yes.
One subsection 1 or A or whatever after that. So what I understand from 57 is that assuming that you had a lease, but when it is a court sale, the court has the authority to pass an order to discharge those encumbrances so that the new owner which purchases will not have those encumbrances. So there is the problem which you are you actually face in field, because the court has the power, the DRT has the power to discharge all these encumbrances. But otherwise, under the Transport Property Act, if you have a lease, the sale will not affect the right of a lessee to continue with the lease. But the exception is DRT, because what happens is that in a few cases I have seen earlier, because now I don't keep a track, what happened was the tenant who are there in the tenanted premises, when the bank takes over and gives the income to the new purchaser, it is without those encumbrances. They are thrown out by applying under section 14. Well, then it leads to a situation where the tenant will have to come under the Rent Control Act to secure what you call their continued position by way of an injunction. That is a practical aspect, but now in these few years, if there is a change in the law, I don't know. So that is the real problem you will be facing.
I think there is a recent decision of the appeals court where the lordship has said, although, my lord, section 35 start with the non-obstacle clause, even then, my lord, the statutory protections that were given to the tenant, that cannot be bulldozed. There is a decision, I think it came way back in 2018 or 19, something like
I am
that.
not aware of the recent development.
So that
No.
protection is given to the
That
tenant.
protection is there.
My-
Okay. But I'm not aware of that. If that be so, then you are protected.
I'll check that one. But then here is the case, my lord, it was moved in 2014.
I understand, but
No stay, there is no stay, my lord. And in the auction purchase sale, my lord, none appeared, my lord. Nobody has offered any bid. And this has been pending for all these years, my lord, in this manner.
No, but we can just regulate you because he is right priority of the secured creditor. Mr. Tata is referring to Kotak Mahindra Bank, huh?
Your lordship
Excise.
may come to the next page, my lord. I have a tick mark, your lordship, see that. We find that from there. We find that given the aforesaid position, there is no need to go into other issues sought to be raised by either of the parties before us or through the impugned judgment, but suffice to say that the respondent bank cannot be prevented from exercising its rights as a secured creditor
Correct.
on the pretext that there is a debt to the excise department arising from the confiscation order dated so and so. So therefore, law is, my lord, sufficiently clarified now. And another decision, my lord, it came way back in 2015. My lord, their lordships held,
No, there is one judgment where there is a very clarity
yes,
that since this is a new law
my lord.
and it gives a priority,
Right.
that means it overrides all other action
Yes,
laws.
yes, all other acts. Your lordship will see that it starts to its non-obstante clause. 31B.
No, it's okay, but there's an interpretation made by Supreme Court in one of the cases I have read earlier, where it says that since here it says non-obstante clause,
Well.
therefore it has been interpreted to mean that it will override all other acts.
Right.
Is that mentioned here also? No.
It's not, my lord, the provision of the law is clear.
No,
31B.
but that has been interpreted.
Well.
I'm aware of it.
And so far, my lord, another decision.
But Mr. Datta, when I'm relegating him back to the DRT, I'm not inclined to
My lord,
pass
I
any
understand that.
observations.
And the totality of the thing, your lordship will find whether this writ petition is maintainable at all. Now,
No,
if there
even
is
if I
a,
hold that it is not maintainable, then also I relegate him to the DRT.
now only in
Even
a
after,
case,
even if after I hold that the petition will otherwise be maintainable, I will still say that since there's a special law to deal with it, therefore we refrain from exercising our discretion and relegate him back to the. So under both situations, I'm relegating him back.
my lord, so far this honorable court as well as the appeals court has said, my lord, writ petition only it can be maintainable if they can show that there is a statutory violation in any case. Now, I don't find there is any statutory violation while disposing of the case by the.
No,
recovery
for that
officer.
I have an answer. Answer is very simple. I won't remember the citation right now, but in GLT it is reported. I think it was authored by Honorable Mr. Justice V.D. Gyani, as he was then. He had said that in the preliminary stage, when the writ petitions are not dismissed, then at the final stage, to dismiss on the ground of not maintainable is not desirable.
Yeah, that decisions appeals court has also said in a Raman Sham case. my lord. That is there. But then here, my lord, the new proposition is this. If there is a statutory violation, in that case only they can come. There is not a blanket order, they
No, but
cannot. come.
2014 matter to say this at 2013 after 9 years.
I'm just
there is
making
not
my
in fact.
submission. It's all up to your lordship.
No, it's okay. You are. I'm not saying you're wrong, but my view is that since I'm relegating him back to the DRT,
You know, with
Yes,
a
yes,
time
agree.
frame, my lord.
within
It
time
was
frame,
a
they can-
very old matter. And
But I really don't want to go into the merit. But it will prejudice either side. I have to give a adjudication, and it doesn't help me.
yes,
If I could conclude the litigation, then it is okay.
and recovery of 59 lakhs, my lord, it's a toll to the economy.
No, it's okay. Yeah, you're right. So, Mr. Chaudhary, I don't adjudicate the matter. I just preliminary points. I'll just take note of the statements made. Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. V. Bharadwaj, Counsel for the petitioner. Also, Mr. S. Datta, Learned Senior Counsel, assisted by Ms. R. Musahari, S. Musahari, Counsel for the respondent number 1. None appears on call for respondent number 2. Next paragraph. in brief, comma, the case of the petitioner is that it is a public sector undertaking and had awarded retail outlet to
That's number 3.
So then you say another revision call for respondent numbers 2 to 6. Earlier, huh? 2 to 6. The case it was awarded to respondent number 3, namely Dvijendra Messrs. Dvijendra DWIJENDRA Petroleum Station, comma, represented by
It's proprietor.
John L. Fustop, Karung KARUNG, comma, proprietor. Wide agreement dated 23/1/2004 and 12/9/2011. Stop. The retail outlet was set up on a plot of land which is covered by the schedule of lease deed dated 1/11/1993, which was subsequently registered on 31/3/2004. Full stop. As a lessee in respect of the said land, comma, the petitioner has been paying rent to the respondent number 3. Correct?
Number 2, mile.
Respondent number 2.
He's the
Okay,
lessee.
to respondent number 2. Namely Sarungbam, SARUNGBAM, Dvijendra Singh. Full stop. The petitioner came across auction sale notice published in the local newspaper on 1/4/2012. Wherein it was stated that the auction would take place, would be conducted by the recovery officer, Debts Recovery Tribunal, Guwahati, in connection with DRPC number 712 dated 27/8/2008. Issued in OA number 28/2007. Full stop. The learned senior counsel for the petitioner contends that the lease commenced from 1/11/1995 for a period of 30 years. Full stop. Accordingly, it is contended that the lease was a pre-existing lease, and therefore fraudulently the leasehold land was mortgaged to the respondent number 1 bank without any intimation to the petitioner. Intimation of the information to the petitioner. Accordingly, on the ground that the creation of lease was suppressed from the respondent number one bank, and that the petitioner has a legal right to continue to operate in the leasehold land. The present writ petition has been filed under Article 226 of the Constitution of India. Still the auction proposed in respect of the leasehold land by the recovery officer, Debts Recovery Tribunal, Guwahati. As well as the auction sale notice dated 1/4/2012. Next para.
One point, if I may, my lord, just.
Pardon me?
He has also, my lord, claimed to be the, my lord, dealer of all, IOC, which he is not.
Pardon me?
The respondent number two, my lord, while mortgaging the property, he has also described himself as the, my lord, dealer of Indian Oil Corporation, which he is not.
Oh, okay. Next para. The learned senior counsel for the petitioner further contends that that while mortgaging the land on which the retail outlet was operating, the respondent number two, no, sorry, respondent number three. No, it is by number two. Okay, respondent number two
Yes, my lord.
had made a false statement that he is a dealer of the petitioner corporation, which was not, in as much as the Indian Oil Corporation Limited had taken the land on lease and was operating the retail outlet.
And the respondent number three has been appointed as the dealer,
And the respondent number three
Right.
had been appointed as
as the dealer.
the dealer. Next one. Per contract, the learned senior counsel for respondent number one has questioned the mentality of the writ petition on the ground that the recovery officer, Debts Recovery Tribunal, was competent to adjudicate the issues raised in the present writ petition. It is also submitted that under the provisions of section 31, capital B, don't give bracket, 31 capital B, of the Recovery of Debts and Bankruptcy Act, 1993, notwithstanding anything contained in any other law for the time being in force, the respondent number one bank would have priority over the security assets, i.e. the mortgaged land. Accordingly, it is submitted that as the respondent number two or three, who's your debtor?
Beg your pardon.
Who's your debtor, number two or number three?
Respondent
Respondent number two.
Respondent two.
Respondent two.
As the respondent number two is the debtor of the petitioner, respondent number one bank. And the bank's dues pertain to the year, which year? The loan become bad when NPA?
My lord, it became NPA on 2008.
In 2008, when the account of the respondent number two, three had become NPA. No, sorry, two. Respondent number two.
Yes, my lord.
debtor is to number two,
Yes.
had become NPA. And accordingly, it is submitted that the the recovery certificate was drawn for a sum of rupees 56,871 with future interest at the rate of 14.5% per annum. It is submitted that the present outstanding would be a huge amount. So accordingly, it is submitted as the dues of the respondent two has been adjudicated in the recovery in the OA proceedings before the Debt Recovery Tribunal, Guwahati. No case is made out for setting aside or questioning of the recovery of the auction of the dues of the bank by way of an auction. So in support of the priority of the dues of the respondent number one bank, the learned senior counsel for the respondent number one has cited the case of superintendent, Central Excise and Customs versus Mrs. Kotak Mahindra Bank Limited and another. You have the SEC citation of this, Mr.
My lord, I tried to find it out. I did not find.
Not there. Civil appeal numbers 6900-6901/2011 decided by Supreme Court of India on 12/8/2021. Stop. It is also submitted that notwithstanding the projection by the petitioner that the lease deed was executed on 1/11/1995, but in this case, the respondent number two had created equitable mortgage by deposit of title deed on 18/8/2002. Oh, sorry, on 16/3/2002.
16/3/2000.
16/3/2002. Whereas the lease deed was registered only on 31/3/2004, which is subsequent to the creation of mortgage. And accordingly, it is submitted that the respondent number one bank would have priority over the mortgage land. Anything I have missed out, Mr. Chaudhary and Mr. Datta?
I think it's all covered. Only thing, my lord, NPA possibly in the year 2006.
NPA,
NPA, your worship has said
NPA, we-
2008, it will be 2006.
okay, NPA, question 2000,
Six.
give it, give the year, don't give date, give year 2006.
Nice.
Okay. Next paragraph. Mr. Chaudhary, please come to page 76.
My lord.
Uh, Oh, so prior to that, okay. 7/6/2013, you appeared. That is page 71.
Yes, they
Nice.
appeared.
Oh, acha, in Mr. Datta's submission, I'll just add one more thing. Mr. Datta's submission. The learned senior counsel for the respondent number 1 has further submitted that although United Bank of India is arrayed as the respondent number 1, but by way of reorganization, the United Bank of India is now merged with Punjab National Bank, and the reorganized entity is in the name of Punjab National Bank, and that the United Bank of India has no existence at present. Next one. It is noted that the Debt Recovery Tribunal, by order dated 7/6/2013, had moved the had just take it out. It is noted that in the proceedings before the recovery officer, in connection with OA 38 of 2007, the petitioner herein had appeared before the recovery officer, Debt Recovery Tribunal Guwahati, and had moved an application bearing petition number 95/2012, not to sell the properties described in Schedule B of the recovery certificate. Inter alia, on the ground that the land was leased out to the Indian Oil Corporation Limited on 1/11/1995. For which the mortgage was non-est in the eye of law. and that the respondent number 2 had played a fraud.
That's number one, madam. Oh, sorry, madam. That's number two.
Two, here it will two. Had played fraud upon the respondent number 1 bank by mortgaging the leasehold, the leased out land to the respondent number 1. However, both the contentions was rejected by the recovery officer. Firstly, on the ground that the petitioner had not approached the civil court for declaration of the right.
And that we have not preferred any appeal against the,
And that the petitioner had not preferred any appeal against the order of attachment.
no, madam, against the judgment, madam.
Hmm?
Against the judgment of the, matter. Against, I have not preferred any appeal against the
Oh,
judgment.
I know appeal has been preferred against the judgment and order passed by the Debt Recovery Tribunal Guwahati in the original proceedings of OA number 38 of 2007.
Right.
Next paragraph. In view of the order proposed to be passed, the court has not entered into the merit of the stand taken by the learned senior counsel for the petitioner as well as learned senior counsel for the respondent number 1. Full stop. In the considered opinion of the court, as the petitioner has approached the recovery officer, Debt Recovery Tribunal Guwahati with a plea, the recovery officer, Debt Recovery Tribunal, Guwahati, ought to have disposed of the petition number 95 of 2012 in its own merit. The relevant facts which are also narrated, which are also partly narrated here before, were available with the recovery officer, Debt Recovery Tribunal. So therefore, there was no impediment on part of the recovery officer, Debt Recovery Tribunal, Guwahati to adjudicate and decide petition number 95 of 2012 in its own merit. Next, accordingly, the court is inclined to relegate the petitioner. He once again approached the recovery officer, Debt Recovery Tribunal, Guwahati, along with a certified copy of this order, and on the petitioner approaching the said learned tribunal, the recovery officer, Debt Recovery Tribunal, Guwahati, shall restore the petition number 95 of 2012 to file and expeditiously hear and dispose of the said petition, preferably within a period of 30 days from the date of receipt of certified copy of the order. Next paragraph. It is clarified that this court has not entered into the merits of the stand taken by the petitioner and the respondent number one, and accordingly the Debt Recovery Tribunal, the Recovery Officer Debt Recovery Tribunal, Guwahati, shall adjudicate the matter in its own right without being influenced by any objection that might have been made in this order.
Perhaps the earlier order has to be set aside, my lord, otherwise the recovery of.
Okay, okay. For that, so, in order to enable the recovery officer to decide the matter on merit, comma. The impugned order
Which is 7/6.
in 7/6/2013 is interfered with. So accordingly, the said order shall not prejudice the parties when the matter is reheard. When petition number 95 of 2012 is reheard. The petition shall disposed of.
Obliged. Your lordship has granted me 1 month time to approach the tribunal.
No, for that will give you 7 days time to approach the tribunal.
Let me 2 weeks, my lord, some preparation affidavits.
2 weeks. Okay. The petitions were, that earlier I have said that petitioner, no, the petitioner shall, no, just hear me first. I have said earlier that he will, please look at me. I have said somewhere that he will approach the recovery officer again with a certified copy of the order. Say there within 2 weeks. And on the city the same, it will be adjudicated within a period of 1 month.
Obliged. Highly obliged.
My lord, I have another prayer, not in the context of this case. My lord, we have been deprived of hearing each other because of this barricade.
Yes, my lord.
My lord, if it can
Yes,
be
sir.
removed.
No, it will be done. What had happened was, this was very costly affair.
Right.
But since I felt difficulty in interacting with the with you,
Yes,
so I asked them to remove it. So they are doing it because they will have to dispose of such a big glass,
right.
and it's a very costly
Yes. yes.
affair.
Since
They are
the,
doing it.
this corona
Only
has
by
gone.
the increase in the volume of the 2 microphones will perhaps for the time being, till it is removed, my lord. The volumes may be increased so that my lord.
No, it gives us noise, that radio noise which
Yes,
comes.
yes, yes.
I understand that, my lord, during the holidays, they could not finish it. I know, my lord, that is being done.
Oh, there is always a story with all matters. When they did it, my court master was not consulted,
I see.
and so therefore this remained.
In one of the,
It was a holiday, so my court master was on roster duty. So he was not consulted while doing it. They only removed this and then this.
my lord, in one of the another.
I think somebody may have given them idea that lawyers are always at loggerheads. So they thought,
So that they cannot have fish fighting inside.
My lord, other day, I made a submission before the Justice Devashi Borua. His lordship has said, you are in the safer side.
yeah, that's what I'm saying.
Exactly, it has come from you.
There cannot be fish fighting, my lord, between the lawyers.
No, they can't be.
But the council of, especially Guwahati High Court, my lord, they are too gentle. The people, the advocates who come from outside, they used to say. So therefore.
No, that
those-
is true. That is true. That is true.
So therefore, removal of this will not make any problem to us.
No, it'll be done. I think give them some time. They'll have to interact again. He'll have to write to the
Yes.
registry. Registry will write to the PWD that I think for a few days you'll have to tolerate this.
We have been tolerating, no problem for that. Obliged.
Highly obliged.
Item 5.
May please, Lordship. Lordship, the petitioner has been running his shop, Lordship, since 1998, like other similarly situated persons, Lordship, and this shop was provided by the Panchayat Authority, Lordship. Lordship, in the year 2013, Lordship, on 14/5/2013, the president of Panchayat, Lordship, issued a notice, Lordship, to vacate the shop, Lordship, that is page 9, Lordship, Annexure A, Lordship. Without any reason, Lordship, this notice is issued, Lordship. And after receiving this notice, Lordship, the petitioner approached the president as to the reasonableness of this notice, Lordship. And the president assured that he will not do anything and
No, you see, the issue which you have raised, you'll have to approach the civil court. We are not adjudicating these matters.
Lordship, in spite of the service of notice, Lordship,
No, he may be a president now, he may not be a president now, we don't know.
Lordship, the president term is already over, Lordship.
So therefore, you have not amended it, your petition goes on that ground alone.
The reason behind this, I have stated in paragraph 7, Lordship, why this notice has been issued, Lordship, that the petitioner stated that in the meantime, the president's home book.
No, you see, there is a different reason why we are not interfering.
Lordship.
Number one, you say that the bills were made without your knowledge. In respect of those bills, you have not made any prayer. Correct. So 14/5 is the impugn order. In 45, you have given a time to vacate the room. So if you don't want to vacate it, you'll have to approach the civil court and get yourself adjudicated. You know, fundamental right has been affected by a notice of eviction. The fundamental rights are not affected.
And as per the Lordship, the interim order, Lordship, when the shop was locked, Lordship, by the circle officer, the lock was removed, Lordship.
No, you show us, you show us a document by which you were given, allotted this house,
Lordship.
that you don't have. You are not allotted these shops legally. Therefore, you can't go and stay and get an order of approval of the court. This land is a PWD land.
Lordship, as per instruction, Lordship, this shop was provided by the Panchayat authority under the Panchayat scheme, Lordship. This shop was constructed by the Panchayat authority, Lordship.
Where is the statement?
Lordship. Lordship, paragraph 3, Lordship.
Paragraph 3.
Lordship.
Doesn't save you.
Lordship.
Doesn't save you. You see, this land was on the PWD land. That is something you have not denied anywhere. That will not help you. We are at the hearing stage and you still make a prayer that you would submit the receipt. Once there is no allotment of land to you.
Lordship, may from one time so that I can get the. Lordship.
No, I'm dismissing it. You can't play with play like that. You see, there are other reasons also. Number one, the ground on which I will be discussing is number one, when you were allotted the land, there was no public, there was no, what you call, public participation in the allotment of house to you, that shop. All persons who are eligible must have a right to compete for that shop.
Lordship, Lordship.
So it is on that ground I am interfering. And you have been only given a notice. You respond to that notice, the High Court doesn't come here. You have reaped the benefit for 9 years. That is more than good. Your allotment is not in consensus with the public distribution of largesse.
Lordship, the applications were invited, Lordship, to from the general public so as to.
Where is that? No statement is made. You're not said, you see, when there is a public auction for that shop, you think the shop will be given to you privately without any documentation.
No, Lordship, after applying the shop, Lordship.
So therefore you are given possession without any documentation. No lease deed, no agreement, no rent agreement. You're just given like that. And then you come up with a story that what you call that daily hajra was withdrawn by the president.
Lordship, the president prepared a bill against the job card.
So therefore you don't pay rent also. You're just given that premises for free. This is something we are not entertain. Your name?
And Hawk, Lordship.
Mr. N. Hawk, I am counsel for the petitioner. Who is appearing for the respondents? Mr. M. Sethia, government advocate, appears for respondent number 2 and 3. For the PNRD, nobody is there. None appears on call for the PNRD. Representing respondent numbers 1.
Also not been shown value in the both this.
Huh?
Their
It's
name
okay.
also with this.
1 and 4. So. Give me the part 2 file. ED card for respondent number 5. Part 2. Oh, I'm sorry. Insofar as respondent number 5 is concerned, it is seen that although order to take steps on respondent number 5 was passed on 26/9/2014, but steps was issued under memo number 5148 dated 17/11/2014. As per the AD card, the notice was served on 22/11/14, which is beyond the returnable date. So therefore, service of notice on respondent number 5 cannot be deemed to be duly served. Next, but nonetheless, comma, in view of the order proposed to be passed, comma, issuance of fresh notice on respondent number 5 is dispensed with. Next, paragraph. The petitioner claims that our shop was constructed under the Panchayat scheme. And in the year 1998, the then secretary of the Bardubat, BARDUBATUP, Gram Panchayat, had handed over the position of the shop premises to the petitioner. First of the, it is projected that the said shop contains 4 rooms. Full stop. The respondent number 5, who was the then Panchayat of the Gram Panchayat, issued a notice to the petitioner to vacate the shop premises and agreed by the said notice. The petitioner has approached this court by filing this writ petition under Article 226 of the Constitution of India. Next paragraph. In this writ petition, there is no statement to the effect that the Gram Panchayat had issued any public notice to invite applications for the shop. And there is no statement that any agreement that the petitioner took over position of the said shop on the basis of some allotment letter and or any agreement with the BARDUBATUP, Gram Panchayat. Stop. The petitioners also not disclose the rent which was agreed to be paid to the Gram Panchayat. Rather, comma, the petitioner has set up a story that the respondent number 5 illegally prepared bill for a sum of rupees 150, rupees 1670 and rupees 1670 and deposited in the name of the father of the petitioner. Deposited name in the bank account of the father of the petitioner.
Lordship, the first amount is 1503, Lordship. Page
I don't know, you have written page 5, you have written 150.
Lordship, that is.
Then-
Yes, Lord.
Under such circumstances, the court does not find that the petitioner has any vested right to occupy the shop rooms in respect of which the notice of eviction was issued. First of all, in view of non-disclosure of relevant facts, it appears that the petitioner was allotted the shop rooms on pick and choose basis. Next, therefore, comma, as the petitioner has not been able to establish his vested right to continue to occupy the shop in question, the court finds no reason to interfere with the impugned eviction notice. Dated 14/5, notice number capital BGP stop 01/2013-14 Miss MIS /22 dated 14/5/2013. This is page 9, flag. Next, but accordingly, the court is disinclined, not inclined to interfere with the impugned notice. Next, but be that as it may, the petitioner is permitted to file his written statement against the impugned notice dated 14/5/2013. Before the President of the Secretary, Barduba Part Gaon Panchayat, within a period of 15 days from today, and on along with a certified copy of this order, and on such reply of the written statement being submitted, the President of the Secretary of the Barduba to BARDUBATOP Gaon Panchayat shall pass appropriate orders thereon in accordance with law. Next one, the learned government advocate shall also transmit the order of the order passed today to the Deputy Commissioner Morigaon, within bracket respond number 2, so that the order can be communicated to the concerned Gaon Panchayat. The patients can dispose of.
There was the interim order to carry on with the
Interim order passed earlier stands vacated. After that, you write the petition stands disposed of. No, after that order, petition disposed of, interim order passed on 29/6/2014 stands vacated. I think I'll not have time to continue with other matters.
Item number 7, your lordship, is fixed rate or?
Just do it. Just give me 2 minutes. There are 2 orders for corrections. Just pass it. That's just 5 minutes.
Production list item 1 and 2.
What is the what is the incorrect?
Paragraph number 3 of the order, lordship. At page 14, relevant page.
Page 14.
Yes, it is projected that the petitioners are now aged 10 to 12 years and are aspirants to admission to class 9. So instead of in place of class 9, class 6 should have been there.
Class 8.
Class
Only that much.
class 8, 9 is written here.
It will be class 8.
6, lordship.
6.
And the documents will be submitted on or before 12/5/2023. So 12/5 can't be because selection list was published on 19/6. So the second week of July is the tentative last date.
This will be 6.
Lordship, in place of class
Class?
9, 6, class 6.
6. And 12/5, it should be,
It should be on or before tentatively second week of July. The exact date of last date is not known to the petitioners.
uh, Mr. R. Bora, counsel for the petitioners. And Mr. K. Gogoi, learned CCC, appearing for the respondent numbers 1 to 4. Oh, no, we can't pass on orders. These authorities will have to be here. That's right, you're right. Mr. M. Chetia, government advocate, appearing for respondent number 5. And Mr. R. Dhar, learned standing counsel for respondent numbers 6 and 7. Next paragraph. This interlocutory application has been filed for correction of typographical error, which is correct in paragraph 3 of the order dated 13/7/2023. Stop. The reference to class 9 shall now be read as class 8, and the date of, sorry, 6 is not 8, 6. Roman 9, Roman 9, Roman 6. And reference to date 12/5/2023 shall now be read as second week of July 2023. Next paragraph. The corrected paragraph 3 would now read as follows. Just retype it again, 3 with these corrections. Next paragraph. In terms of the petition stands, this interlocutory application stands allowed by incorporating the corrections in paragraph 3 of the order. Both same.
Both same.
Okay. In that page 14, I have written by pencil. Page 14, I have written by pencil corrections. Mr. Das,
That will be a Thursday or next Tuesday.
which one?
Item number 7.
Not take that much time.
Item number
7.
7.
There is an interim order.
Okay,
7 and 8.
7 and 8. When do you want, Mr. Das?
Thursday or
Lordship,
next,
I-
not next Tuesday.
Interim order is against us, Lordship.
It's okay. He is not asking for a long time. Mr. Das is not asking for a long time.
They have not filed any affidavit in government. Yes. I don't
Lordship,
know.
it's only on law point, Lordship, only law.
It's okay. 20 then?
Yes.
20.
Okay. Due to positive time, matter could not be taken up today, based on 20/7/2023.
Lordship, can we upgrade it and on that day, Lordship, at 2?
No, it's,
Or
this
it's
is a
always-
pencil. We'll try to take it up. Upgrading, I don't know. I'm not putting the order.
No, it's on that day, Lordship.
No, I'm not saying anything right now because there are nowadays every hearing day in my courtroom, this top of the list matters would be coming up.
In some.
My
So,
lord, item
I'm not
number
committing
6,
anything.
The election matter, my lord.
Huh.
But we have it in short date, my lord.
Oh, election matter is there today.
Yes, my lord. Item number 6.
Item 6. Due to both sides are duly represented, due to positive time, matter could not be taken up today. Oh, no, not both sides. Counsel for the applicant is present, due to positive time, matter could not be heard today. List on 20, 25 or 27th.
27, 25 with elections.
Okay, 27/7/2023.
I'm obliged.
Okay.
So item number 10, that is a motion matter. Can it be fixed tomorrow also? Item number 10.
What is this matter?
This matter, lordship, petitioner number 1, who is a married woman, lordship, left her matrimonial house on her own will, lordship. But the husband will file a missing report
and forcefully trying to take her back with the help of police, lordship. And
For that, we can't give you relief. Your retribution would not be maintainable.
no, lordship, missing report is there, therefore
No,
the
no.
police is
Think
threatening
complaint,
the
my lord,
petitioner's
not
lordship.
petition.
No, no. You see, what has happened is, you look at your own story,
Lordship.
look at your own story. She's a married woman.
Right,
The husband gives a missing report.
lordship.
What
After-
is wrong for the police to recover her?
Yeah.
No,
If you
already-
don't want a residence,
Got it.
you'll have to approach the competent court and get a injunction.
was
No, no, that you don't want to reside with the husband.
No, that on the basis of the missing report.
No, no,
lordship,
supposing you see, take an example.
Yes.
My son has left my house,
lordship,
correct?
lordship,
He has left the house at his own will.
lordship.
Now I go and lodge an FIR. What is wrong in that?
No, in that case, lordship, there is no wrong, but in my case, lordship, on 20th, I informed my husband about leaving the house, lordship. And
No, no, no,
subse-
no,
and,
no.
subsequently. he
You'll
lost
have
the
to
case.
approach the civil court and
And-
get an injunction. You see, the reason is very simple. Now, for whatever reasons you are, you don't want to cohabit with your husband.
Yes.
Correct, but the prayer for writ would be operative against a private individual.
No.
A
regarding-
private individual has lodged a FIR.
No, only in respect of that missing report, because
No,
police
no,
lordship
you see,
visited the
You
house.
look at from the different angle. Once you change your spectacles, you'll see differently.
Lordship.
You see, the husband lodges an FIR
Yes.
that the wife is missing.
Yes.
If the police doesn't investigate,
Yes.
then what happens? It will be violation of the Supreme Court directions in, starting from DK Vasu till
Lordship.
the current, what you call laws. So therefore, if the police investigates the matter,
Yes.
how can the court come and step in and say that you don't investigate? This is not 482. We are under 226.
Even they are come from
And,
passing of their missing complaint, my lord.
And lordship, may see in my paragraph also, I have stated that police visited the house. I have informed them, but still they are not producing me before the magistrate or to record my.
You can surrender before the magistrate.
Because the victim herself on oath saying, lordship, see, on her own will, lordship, left her house.
No, but in the writ petition, I can't take cognizance of a self, what you call prepared document.
Thereafter, also I will practice.
No, because the view will not change. This is something I have seen and come.
Yes.
So time will not be a constraint.
Thereafter,
The only thing is that you can withdraw this and go to the, will give you liberty to approach the magistrate and surrender before the magistrate and end of the matter. Because before the magistrate, you go and say,
because Iowa is not informing whether any other cases laws against him or not. Because only threatening is given that I will put you behind the bar on charge of kidnapping.
no,
He's
that
not
is okay.
disclosing that part also.
No, that is okay. If an FIR has been lodged, there will be some Ilaka magistrate to take up the matter. This police station falls under which jurisdiction?
Morigaon police station.
So Morigaon police station, if it is Morigaon police station, it will be the chief judicial magistrate. You surrender before this chief judicial magistrate and we will give you liberty.
But that observation may be given in that case.
We'll give you that observation.
Yes.
Correct?
Yes.
We'll dispose of the petition on that ground.
Yes.
Heard Mr. A. Ahmed, counsel for the petitioner, and Mr. M. Setiar, government advocate, appearing for the respondent numbers
1 to 4.
1 to 4. Petitioners, S. Next paragraph. In view of the order proposed to be passed, issuance of notice on the respondent numbers 1 to 4, as well as private respondent number 5 is dispensed with. Next paragraph. The petitioner number 1 is the wife of respondent number 5. It is projected that due to physical and mental torture, the petitioner left the matrimonial home and is residing in the house of petitioner number 2. Full stop. The Respondent number 5. You are left the house on when? Which date?
In the first part of May also. I have informed him on 20/05/2023.
Sorry. It is projected that the petitioner informed the respondent number 5 of leaving the matrimonial home on 2/05/2023. However, the husband, i.e. petitioner number 5 had lodged in, respondent number 5 lodged an FIR on 21/5/2023 regarding missing of his wife, i.e. the petitioner number 1. This is registered as missing report 66/23 before the Morigaon police station. Police full stop. The learned counsel for the petitioner has submitted that the police personnel had come to the house of the respondent number, petitioner number 2. And the petitioner number 1 informed the police personnel that she has left the matrimonial home. Full stop. Therefore, the petitioners have approached this court for protection of their life and for the life by quashing the missing report in respect of the petitioner number 1. Next para. In this case, the petitioner has projected that on 25/2023, she had sworn an affidavit to declare dissolution of her marriage with the respondent number 5. Full stop. As a read court, the proposition of the petitioner number 1 is totally unacceptable, as it is not lawful. Full stop. If the petitioner number 1 has any intention to dissolve her marriage, there are appropriate court and forums created to enable the petitioner number 1 to do so. Full stop. On a legal appreciation of the matter, at present, the court is unable to accept dissolution of marriage insofar as petitioner number 1 and respondent number 5 is concerned. Therefore, her cohabitation with her living together with petitioner number 2 is contrary to the well accepted tenets of law. What is the spelling of tenets? TNA?
She is
Yes.
residing as a tenant person, not in. They were, the petitioner number 1 is residing as a tenant in the house of petitioner number 2. They are not in a relationship. I have stated in my petition also. In page 5, last 3 lines, document analysis. Page 5, paragraph number 3, last.
Where is it stated?
Page 5, paragraph 3, last 4 lines.
Page 5.
Paragraph number 3, last 4 lines. From bottom. Finding no alternative, petitioner number 1 left her matrimonial house on her own and started residing in the house of petitioner number 2 as tenant.
Para number
Three,
3.
page 5.
Last 5 lines. From below.
Acha, it is residing in the house of petitioner number 2 as tenant. The petitioner is also not assigned any reason why she could not resume her, could not go back to her parental home. Full stop. Moreover, comma. Strangely. The address of the petitioner number 1 and petitioner number 2 are different. Full stop. Be that as it may, comma. Next paragraph, be that as it may, comma. If the petitioner has left the matrimonial home, comma, despite a missing report, made by the IO of Morigaon Police Station, comma, the under the judicial setup, comma, definitely a judicial magistrate would be assigned for the Morigaon Police Station, which may be the chief judicial magistrate or any other judicial officer in the district judiciary. So therefore, comma, if the petitioner number 1 has left the matrimonial home at her own volition, comma, it would be open to the petitioner number 1 to surrender herself before the jurisdictional magistrate. Having jurisdiction over the Morigaon Police Station and have a statement recorded of leaving her home in her own volition. Full stop. If the petitioner feels threatened by any person, comma, it would be open to her to lodge lodge a complaint before the police to indicate the names of persons who are harassing her. Full stop. Next paragraph. Essentially, to accept dissolution of marriage between the petitioner and the respondent, petitioner number 1 and respondent number 5 would not be in accordance with law, because the petitioner has not obtained a decree for either judicial separation or divorce, and therefore on the said ground, the court is disinclined to entertain this writ petition, and accordingly the same is dismissed in the motion stage without issuance of notice on the respondents. However, comma, with liberty to the petitioner to approach the jurisdictional magistrate as indicated above. With these set of observations, the petition stands closed.
So one observation may be given, lordship, that IO will not harass the petitioner's lordship in connection with
After
the
CGM,
missing.
after appearing before CGM,
Yes, ma'am.
No, till the 15 days.
No,
lordship
no, no,
time may be
not
granted,
even
I will
for a day.
accept.
Not even for a day. This is something which I will not accept. That is why I gave those reasons. Somebody giving a affidavit saying that I have divorced him.
That part I am not on that. lordship.
So then, therefore, if I give them
No, I am
production,
not on that, lordship,
if
for
I
the-
give an observation on that, it could amount to giving a legal sanctity to that I am unable to give.
I'm only on that she is being, the police is trying to get her forcefully. lordship. That
It
part,
can't
that
be.
part.
You have given your separate addresses. I have seen all those
Yes,
things.
it is there, that those are permanent address I have given.
That is why I was compelled to write. I don't know, but I'm not giving any protection.